Wishes to all for the new year. On behalf of both of us. Yes,
Fresh writ appeal for
pardon,
fresh writ appeal.
what is the urgency?
Agency is it's a service matter. He's a general his general merit to physically handicapped category. He was not been appointed, my lords. So we filed a writ petition before a single judge. But considering the eligibility criteria, the writ petition was dismissed. There was an interim order in operation to reserve one post. That interim order, for that we are moving the matter.
Interim order is expiring when?
Insofar as because nobody was appointed to that particular.
Today interim order is operating,
No, man. The writ
3rd March.
right. Anytime in February, not May request. Anytime in February, may request.
If you wait, then it will post it earlier than what
I
week?
complied with the office objection almost about 15-20 days ago.
If you wait for normal listing, it might be listed earlier than what we give. All right. Then February 3rd.
Kind.
Serial number 52, filing a memo to withdraw it. Petitioner is also present before the court.
PIA.
Yes, my lord. Government has taken action and then, my lord, now registered an FIR against, my lord, 3 accused, my lord, who are running the respondent number 13. So, PIR may not survive, my lord. Also filed, my lord, in the registry as well.
This public interest petition was filed seeking a prayer to constitute a special investigating committee to investigate into the alleged malpractices committed by Dispensary of 8 to 11 banks and the officials. The allegations were made about the collusion and malpractices in the petition. Today, when the petition comes up for consideration.
My lord, there was a direction to deposit 1 lakh.
You not paid cost, then will not permit you to withdraw.
But in terms of petition itself will not survive, my lord. We filed this petition in 2020.
Only recently in one of the order,
I will pay the cost.
pay the cost, then come.
Yes.
By order dated 1/7. By order dated 1/7/2020, this court imposed on the petitioner a cost of ₹1 lakh to be paid within 4 weeks. Today, when the petition comes up for consideration, it transpired that the petitioner has not so far paid the cost. Most of the cost shall be paid in compliance of the order dated 1/7/2020, whatever it is, 20, within 1 week from today. The petition may be permitted to be, the petition shall be listed next Monday,
Yes, next Monday.
15th of January.
Serial number 58, my lords.
58.
58. I appear for respondent. The matter is posted for non-payment of process fees, but I take notice for the respondents, my lord. I'll file the wakala during the course of the day.
No, we have not so far issued notice, Mr.
Notice is issued, my lord. Stay order is in operation as well in that matter. They have not.
It is already issued,
Yes, I became aware of the proceedings. I'll file wakala during the course of the day.
so you want time.
Matter may be listed on any other date, my lord. Copy, I'll receive it from the counsel for the appellate. 18th, may I request contempt. I filed in a similar matter.
10th February,
18th of January, may I request.
18th of January.
Kindly. Contempt is listed on that day. It may be
Then
taken.
18th January is working. 20th January,
19th.
20th January.
20th January is a Saturday.
No,
I'm sorry. It is-
you are looking at the
Sorry,
last
this is
year.
the calendar.
20th January is Monday.
Kindly.
With your lordship's kind indulgence, my lords. Serial number 26,
26.
26, my lords.
Yes.
And request is a little accommodation is required in this case, my lords.
When do you want?
Not any date, my lord.
21st of
This month, much obliged.
Serial number 30, my lord. Serial number 30, my lord.
13,
30, 30, my lord.
30. Yes.
I am there for a petitioner, my lord. Senior is out of station. Some
Hmm.
personal inconvenience is that for senior.
4th of February. As requested by learned petitioner, stand over to 4th of February.
My lords, may I make one submission, my lords?
Yes, madam. One.
My
Yes.
lords,
After this,
serial number,
after. Yes, yes. Yes.
my lord, serial number 10, I pray for 2 weeks accommodation, my lords.
Serial number 10.
Yes, my lords, I am appearing for petitioner. I have some personal inconvenience, my lords.
No.
At least this week, and I am not in station, my lords. This week also any date, Friday or Thursday or next week, any date, my lords. I am not in
15th,
station, my lord, that is the reason.
15th.
Oblige, my lords.
My lord, serial number 34, my lords, appearing for respondent number 5. I pray for a short accommodation, my lords, to file our objection. I will
34.
inform the others.
34.
34.
What is that PIL? About what?
Please, my lords, it's a land grabbing. They've sought for implementation of the representation which has been filed, my lords.
You can go to 5th February.
Please, man.
5th February.
My lords,
Your Lordship,
5th of February.
please, man. Very obliged.
Your Lordship, serial
Serial
number
number
57, your
28.
Lordship.
20,
For 28,
28.
28. The council on record for petitioner is not keeping well, he is under medical care. I praise short accommodation.
19th February.
Your Lordship, serial number 57, may I?
57. Yes.
Yeah, Lordship, notice was issued, but the registry are asking for the fresh PF for issue of notice for the second time.
Hmm.
Your Lordship, the file is around 700 pages and there are 9 respondents.
Hmm.
And the total cost is around 20,000 it comes. So if the Lordship may kindly serve it through email or the council who has represented. It is a bulky file, your Lordship.
There is no ground to dispense with any of his objections. Your file, you are bulky. I mean, your.
Lordship, if may I submit, I have already submitted all the copies.
No, let us see. Nothing to be dispensed with right now. We'll see physically when you come physical. Yes.
My lord, I am from Odisha, my lord. Okay. 1 week's time may be given, I may
It will
come.
be given. 21st February, January.
Oblige, your Lordship.
Kind permission. So content matters. So serial number 1, Mr. Shrikant A.
Filing file. Then permit to withdraw this, I'm filing a memo. Needful done by the respondent on last week. Permit to withdraw.
Your drawing,
Permit to withdraw.
learned advocate, Mr. Srikanth,
Srikant.
files memo dated
File.
20, memo dated 6/1/25.
I complied.
In which it is stated that since the order is complied with, the complainant is not interested in prosecuting the present contempt proceedings, dismissed as not surviving. Petition is dismissed as not surviving. Memo shall be taken on record.
Serial number 2, Mr. Surajan, Devarajan.
Was annexure G is the order passed by the government, page 53, my lord. Relevant para, my lord, page 58, my lord.
Notice returnable on 6th of March,
Serial number 3,
little earlier, 24th of February.
serial number 3,
That's not a similar, my lord, page annexure. G,
Same,
my lord.
similar.
serial number 4, Mr. H.J. Anand.
Annexure A is the order passed by the Honorable Court, my lord. Direction is, my lord, to observe the first of assistant lecturer within 3 months.
Notice returnable on 25th of February.
Seal number 5.
For the complainants in this case, the order which is not
Where is
complete
the
is
order
at
of
annexure
15649?
annexure M,
Annexure?
annexure M at page 100, your lordship. Kindly turn to paragraph 7.
No,
At page-
order in 15649. Because the direction is that directed to comply with the directions issued by this court in terms of the order. Dated so and so in writ petition 15649. Where is that order?
So which order? This is here. At annexure F, page 74.
So there, what are the directions?
My lord, the matter has attained finality before the Supreme Court way back in 2023. The complainants have fought the litigation for almost 2 decades. Now the authorities are not conducting Podi and Durasti work in spite of repeated contempt petitions that are filed before this. Kindly see annexure H, my lord, it is the order passed by the apex court, putting an end to the entire litigation. The appeal filed by the state, special leave petition has been dismissed, and the order passed by this court in writ appeal has been upheld. And thereafter, at annexure G had approached this honorable court by filing CCC 140 of 2023. This honorable court has directed the authorities to complete the
So
coding
today,
work.
what is the contempt?
My lord,
They are not accepting your application.
no. They have accepted the application. They are not doing any body work.
Where is that? Where is that direction?
Kindly see the order at page 112, my lord. 112. That is the order, recent order passed by the learned single judge. It starts from paragraph 7.
No, you show that the direction is to carry out the 4D and.
Yes, that's what I'm saying. Page 111. 111. Paragraph 7. Annexure M, my lord. With the above facts in mind, this court is of the considered opinion that the respondent Tahsildar and survey settlement authorities are finding it difficult, to identify the particular pieces of land in terms of the official memorandum, then the Tahsildar shall issue notice to all the 7 grantees as found in the official memorandum dated 26/5/1984 issued by the Deputy Commissioner. The extent of lands granted in favor of each of the 7 grantees is explicitly clear from the official memorandum. The Tahsildar and survey settlement authorities shall fix the boundaries in terms of the lands that would be identified by the 7 grantees and thereafter proceed to conduct Podi and Durasti and assign new numbers to the individual extent of grant. It is made clear that the Tahsildar and survey settlement authorities will not be permitted
But you
to
find out,
decline.
My lord,
find out this law already.
my lord, the direction may be seen, my lord, page 78, paragraph 6. Paragraph 5 may be seen, page 78.
In fact, which are the directions you are seeking to comply with in this?
This is the order, my lord.
Which order?
The order, page 100.
112.
112, yes.
My lord, the basis for that arises from paragraph 5 and 6 at page 78.
I'm talking about the order passed by the then single judge dated
No, that will come later.
26/3/2024.
So technically, she is right that there is no direction to, it is only observation.
Pardon me?
Directions is only to permit you to file application.
No, that has been.
My lord, the
done and that has
application
that has
is
not been-
required to
kindly-
be
kindly-
made
kindly-
online.
Kindly see the order passed by this court
But then
in
you,
CCC.
Very well. my
That has been done. Kindly see at.
Very well.
annexure G.
My lord may grant us some time.
take his application to some logical land.
Very well.
My lord, this court has passed an order on at annexure G on 26 February 2023.
There
Kindly-
is a notice returnable on
Please,
5th of February.
Very well.
Seal number 6, Mr. H. Maltesh. Seal number 6, Mr. Maltesh.
Pass on.
Seal number 7, Mr. Devrajan.
Annexure G is the order passed by the investigation, page 49, my lords. Lords, 11th paragraph, my lords, page 62, my lords.
Then,
Lords, order of penalty, my lords, has been modified, my lords.
correct, from cumulative to simple.
Yes, my lords.
So what is it?
Lords, I made a representation, my lords, on 20th,
They have not given effect.
lords, no, no, lords, it has not been modified. I will retired employee, my lords, I'm a senior citizen. Lords, I'm aged about 74 years age, my lords.
No, no, that is all right, but it is not given effect to.
No, no, my lord.
So today, what is given effect to?
No, no, my lords, it has not been done. They have to modify the penalty, my lords, and refix my pay, my lords. It has not been done till today, my lords. The orders passed about 9 months back.
There is no contempt as such technically. Notice returnable on 12th of February.
Serial number 8.
The complainant is a pilot. Here, his microlight examinership license was not renewed.
Pardon?
There's a court order at page 11, Your Honor. Annexure A, page 11, asking the respondent to renew his license latest by 28.
It's returnable on 17th February.
Much obliged.
This serial number 9. Mr. Manjunath Rao.
Complaint, my lord. This court is directed the accused, my lord, to forthwith restore the name of the RTC in the,
Notice
otherwise it is seriously viewed, my lord.
notice returnable on 11th February.
That date, madam, because my lord, the court is directed forthwith, my lord, forthwith restore the name of the complainant, the RTC.
Therefore,
And there is a, if he is not done, my lord, he is seriously viewed, my lord. Kindly see the order, my lord.
therefore notice, what else? Issuing notice.
And notice, my lord, start date may be given, since, my lord, we are litigating more than 12 years.
So today, except issuing notice, what we can do?
No, it is only Yelahanka Taluk, my lord. It is only 12 kilometers from this.
Government pleader is very alive in terms of hearing, response. So wait till 5th of when it is kept? 11th February.
Sir, 10 is urgent. Serial number 11. Mr. Nataraj Sharma. The PAL.
That's but this petition has become infructuous, it's because what is that being challenged? There's a particular guidelines dated 31/8/2023. That methods has been withdrawn on 18/12/2024. So nothing survives. There are 4 prayers which they've asked, out of which Learned Senior Counsel Mr. Vikram restricted his prayer only for the first part.
First part,
Yes, minutes.
31/23, quashing of 25.
Yes, minutes.
So this was earlier listed.
Yes, it was listed, my lords, and it came to be.
1612, my lord.
But now this, in any case, this is a PIL in service matters.
That's right.
That is what at least I viewed when read.
Yes, my lords. In one matter, my lords, we have the judgment. I can just pass, whereby my lords have held that my lords in service matters, PILs don't
95
exist.
Supreme.
95 Supreme Court, Mr. Duryodhan or something like that.
But in any way, if you are saying that this is infectious, then.
It is infructuous, my lords.
But then appointment is made.
My lords, the appointment, they have come up with new guidelines, my lords.
Appointment is not made.
Appointment is not made. It's under.
So therefore infectious.
Infructuous.
Wait, pass it over.
Yes, my lords.
The green bench matters, serial number 12. So Manjunath G. Kandekar.
Appearing for petition against this, number of cases have been.
Similar matter.
My lord, the notice may be seen, my lord, the date of notice and the prayer.
It is.
But he will say that similar matter.
Similar matters, but my lord may see the
23.
notice dated 22/1/24.
24 or 23?
No, my lord, it's 22nd January 2024. The notice shown is 28th August 2023. She's not seeking for quashing of this. She's seeking for quashing of a notice which is not on record.
Oh, this copy paste
No.
from other petition. This
Page
notice.
8 may be seen, the date and page
No,
6.
page 6 is the same prayer.
Same
24/8/20.
24/8, madam.
Prayer is records the same date, 24/8/23.
No, my lord, in mine it is 22/1/24. And the notice is dated
8/23, madam.
So you have given some advance copy for advance petition.
24/8/23. Anyway, I leave it to my lords.
Give copy, proper
My
copy.
lord, I will. I'll give this one. It's all there.
What kind of order we have had?
Order copy.
Give the copy. That requiring the registration.
Yes, my lord, under rule 15B1 and 2. My lord has disposed of similar matters.
Notice also same date. Same.
No, my lord, the notice is actually 24/8.
Ismail.
Now and then it is at 28/8 anyway.
The order she is relying on same notices, same date.
No, for me it was different.
So many petitions are same date only.
Same authority,
Yes, my lord.
department, deputy director.
Same one.
So. So this can go identical.
Identical.
Verbatim same. So same order you have to reproduce. Same order. Except name of the advocates. What's your good name?
Rajamma. Rajamma.
Rajamma, Miss Rajamma.
It's number 13, Raghavendra Ji Gayatri. Number 13.
This is also deemed
Okay, for the deemed conversion under 95.
deemed conversion, 95.
9 of KLR Act.
Give our order instead of.
Let's.
Page number.
Or latest order.
My lord, could I seek for a week's time to verify from the DC, my lord?
This is that.
That's today morning, I sought instructions from my client. Till now, they have not taken the decision, my lords. Till now, they have not taken the decision. Today morning, I have.
It's just to intimate, my lord, that this writ petition has a week's time.
You want to find out?
Yes, ma'am.
A day, 2 days more. 16th of this. 16th.
Obliged, ma'am.
So we'll say to be listed at 2:30.
Yes, ma'am.
So that it can be disposed of.
Yes.
2:30.
Deeply obliged.
So writ appeal matters, it's number 14. To Gaurav GK.
My lord, I appeal for the appellate corporation, my lord. There is a delay of 66 days, my lord.
Why, but why you have preferred appeal?
My lord, the direction is to, my lord finds the order passed by learned single judge at page 26, my lord, the operative portion.
That's right, but it is.
At page 27, my lord, point number C, there is a direction to assess the property.
You are second respondent.
Please, my lord.
Original, yes. So you are directed to continue assessment of the property as city property and collect
Please,
tax.
my lord. However, my lord,
What is your case?
Lord, my case, my lord, I am placing reliance on certain documents, my lord, which I have placed on record along with an application seeking permission to file these documents on record. before the learned single judge, my lord, there was no opportunity to file my formal statement of.
You don't want to assess the property?
No, my lord. The petitioner before the learned single judge, my lord, places reliance on a special DC's order and a khata issued by the local panchayat, my lord. Subsequently, there are cases that due to accreditation, my lord, it has come within the limits of the appellant corporation, city corporation. However, my lord, there is a direction passed by the state government which has been complied by the city corporation, my lord, wherein we are directed not to assess these properties. I only want to place reliance on those documents, my lord, which I have placed on record along with my application.
Anyway, today there is a delay.
Please, my lord,
Notice in delay application, notice returnable on.
My lord, may be connected with another matter, my lord, preferred by the corporation, which my lords are directed to.
Is it a Kharava land, Mr.?
Please, my lord.
She wanted to resolve this matter.
Is a government Kharava?
Please, my lord. Yes, my lord. Lord, another matter is being taken up on the 11th of February, my lord. Maybe
Notice in delay application.
please.
Returnable on
11th February, my lord. Another matter on similar
11th February.
Great.
So number 15, Sri Hari.
For the appellants, my lords. Appellants are the LRs of original grantee. The land was granted in the year 1965 and it was
35 years delay.
30 years from the date of-
Several petitions and decided. Several petitions.
Only one submission, my lords.
Yes.
Manchegoda judgment is covered to this matter because after 1974, the first sale taken place. The purchasers have not perfected their title.
Pardon?
Purchasers have not perfected their title. Manchegoda paragraph 24 of the Manchegoda.
That is none of your business. You are an original grantee, heir of the grant.
Please, my lords. No, the delay because of the amendment, now latest amendment, my lords. I have gone through your lordship's decision, but
Which is that? Is it bill 835 or 810? Have you seen this?
I have gone through that.
10.
I have gone through that.
Okay. First.
Only relying upon paragraph 24 of Manchegoda, my lords, which says that the purchaser has not perfected his title after the sale in violation of the grant condition, then
the authority will take action.
I
Can't succeed.
have the right, my lords, to.
You are multilated in law because you are coming after 30.
My father has sold these properties without the knowledge of these, my lords. Kindly see paragraph 24, one paragraph, my lords. Paragraph 24, 314, page number 314 minutes.
Paragraph?
Paragraph 24. I read minutes. This is a judgment where the validity of the act was challenged. While upholding the validity of the act, certain observations are there, my lords, with regard to transactions which have taken place in prohibition of the grant conditions. It starts with 24 minutes.
So this goes against you.
No, my lords.
No?
Because purchase is 1974. They have not perfected their title. In 1978, the act came into force. This applies where they have perfected like at least 12 years or long period. That is what the paragraph says, ma'am.
But the first sale was in 1974, my lord. The statute came in 79.
But
The
you
claim is by the legal heirs here.
Pardon?
Claim is by the legal heirs. There's a delay of 35 years after which the challenge to sale it is
that
made.
is the aspect really goes against them, but what the contention is that the time of transfer, the title of the transfer is not perfected.
Please, ma'am. Within 9 years, when
That is
15
because
years
of the
was the
non-
prohibition period. Within 9 years, sale has taken place. That is the.
But one who is coming after 35 years delay cannot take this.
Now, when we have this latest amendment as well as decision of Honorable Apex Court in Satyan Matters, it says even after 15 years, permission is must. Paragraph 31 of Satyan clearly says even after 15 years. Paragraph 31 minutes.
Paragraph
31. After considering Nekkanti Ramalakshmi and Vivekananda, this judgment came to be passed. Kindly see para 31 minutes.
So here transfer was before coming into force of.
Yes.
Please. No. In this case, it is not before the act.
In your case,
In my case, before act coming into.
before copy act coming.
74, 4 or 5 years before the act.
It came into force when?
Now, 1/1/1979.
79.
79.
17.
Read it.
Please. The aforesaid section is applicable for grants made either before or after the commencement of the act. The terms of the grant cannot be contravened, but the last part of subsection 1 of section 4 of the act makes any transfer in violation of subsection 2 also null and void. Subsection 2 of the section 4 of the act is crisp and clear in its terms, putting an absolute ban on transfer after the commencement of the act without previous permission of the government. Thus, a bare reading of the provision makes it abundantly clear that it brooks no two interpretations. After a period of 15 years, also, thus the permission was required to be taken. There is a word that after act coming into force, manners in this, I'm relying upon Manchegoda to say that the purchaser had not perfected the title as on the date of act coming into force. Manchegoda says only the transactions which have taken place, even though they are in violation of the act.
You are there in that group which is.
No, my lords, I am not there in that. Other matters, I am following that matter, but I am not there in that.
So this aspect you can thresh out in the challenge to the validity.
Please.
This may be one of the exceptions.
Please. Satyan, in fact, I brought it to the notice of government advocate there, my lords.
Writ appeal number 1046 of 2024. The present writ appeal is directed against judgment and order dated 23rd November 2020, passed by a single judge, whereby the petition of the petitioner, who happens to be the heir of the original grantee of the land, came to be allowed. On a single judge. This is by whom? This is by purchaser.
Purchaser,
by the purchaser. Came to be allowed on the ground that the original grantee moved the authorities under the provisions of Karnataka, scheduled caste and scheduled tribes into prohibition of transfer of certain lands, Act 1978, seeking restoration and restitution of land after lapse of 35 years. Paragraph. Learned additional government advocate, Mr. Harish, would submit that the challenge to the judgment and order is misconceived, in as much as learned single judge is justified in allowing the petition of the purchaser when the claim of the original grantee for restitution was made after delay and lapses of 35 years. It was the submission of learned. It is the submission of learned advocate for the petition so and so that the transfer of land in favor of the purchaser was
within prohibition period.
Before coming into force of the act. And that in that view, the title of the transferee was not perfected. Full stop. In this regard, learned advocate for the petitioner relies on the decision of the Supreme Court in, where is that? Any other parties there except private parties are there?
Number 3 and 4 are there.
Yes,
Then
private
there is
parties
no- There is no way out. Notice returnable.
Please.
But we are inclined to admit.
Please,
in this point.
much obliged.
At the after, if at all we condone the delay. Notice written on 18th of February. On
Much
that day, just remind us
Please.
about these judgments. Please keep this.
This is number 16, Srinivas SV.
Here also
Petitioner.
delay of 40 days.
40 days.
Notice written on 18th February.
Number 17,
Writ appeal by a bank, my lord, because the learned single judge has directed return of documents, my lord, which were pledged pursuant to one loan. Whereas, my lord, the second loan is outstanding. We have called upon him to make payment, and my lord, proceedings are initiated before the DRT. My lord, I place my rights in two fronts. One, both under the contract, and my lord, and in law, bankers lien, bankers general lien. But I have a right to these documents. And Lord, at this point of time, I'm not doing anything except that release of documents.
The general lien will not extend to the documents.
My Lord, it does. Can I just point out a Supreme Court judgment on the subject? And my Lord, may I first point out the contract between us, my Lord? The deposit of title deeds itself says that, my Lord, it is subject to any other loans, etc. that claims that I may have against them. I am holding these documents. The very first document, the deposit of title deeds, kindly look at page 66.
So same person took two loans.
Two loans, one my lord in his personal name, one my lord in his company's name. In his company's name, he is a surety. He's a surety. My lord, we have called upon him to make payment. We've called upon the my lord, asked the surety to make payment. He has not. We have initiated proceedings before the DRT. At this time, if my lord, documents are returned to them, may I request my lord to first look at the contract itself between us. May I request my lord, can you look at page 66, my lord? This is the deposit of title deeds. Page 66 of the appeal memorandum, my lord, I'm sorry. My lord, kindly see page 66. But this is the deposit of title deeds. Now, my lord, he says, I deposited documents under this title deed, and I am entitled to a return of it.
56 of
66, my lord. 66
of this company.
of the appeal memo. Of the appeal memo. If my lord on 66, my lord will see it's a deposit of title deeds. Now, my lord, it is this under this document that this particular title deed was deposited with us. Now, my lord, can I request my lord kindly look at para 1A, just below that, my lord. Para 1A, and my lord, can I request my lord to go about 12 lines below that? My lord will see it start on the left side, starts with the word mortgage/charge. Note 2. Mortgage/charge by deposit title deeds as security for the due payment to the bank of all or any of the sums of money which then or hereinafter, para 1A, my lord. On page 66, para 1A. My lord, in para 1A, my lord, I'll go down about 11 lines, not 10 lines. It starts with the word mortgage on the left side. Mortgage/charge by deposit title deeds as security for the due payment to the bank of all or any of the sums of money which then or hereinafter were or shall at any time be owing to the bank on account of the sum obtained or to be obtained hereinafter by me, us, the party, or in any in any of my or our parties' accounts, be it current, overdraft, cash, or loan, whether from me or us solely, or from the party, or from either or any of us jointly with any other person or persons, including the amounts of any notice or bills discounted or paid on or at the request of either of us, or solely or jointly, or any money or advances made to or from the accommodation or at the request of either of us solely or jointly, or any money for which I or we or the party may be liable to the bank in any way whatsoever, together in all cases forthwith with interest, so and so on. So for all of these things, the document is deposited. Now, my lord, in the impugned order, my lord, there's no consideration of this at all. So this, my lord, is the contractual clause.
Which provision of contractor will apply?
My lord, can I request my lord, now, may I request my lord kindly look at, in the compilation that I've just given, my lord, may kindly look at the judgment in Syndicate Bank versus Vijay Kumar. My lord, it's the first judgment in that compilation.
Yes, which section?
My lord, sections would be, my lord, section 148 and 171 of the Contract Act.
Contract.
Kindly look at section 148 first, my lord.
One
148, my lord. 148. Not a bailment is the delivery of goods by one person to another for some purpose upon the contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of in accordance with the directions of the person delivering them. The person delivering is called so and so, so and so. Now, may I request my lord to kindly look at section 171. Bankers, factors, board attorneys of a high court and policy brokers may, in the absence of a contract to the contrary, retain as security for a general balance of account any goods bailed to them but no other person shall have a right to retain any such security for such balance, goods bailed to them, unless there is an express contract to that effect. So for a general balance, I as a banker have a lien on documents which are deposited with me. And my lord, documents are deposited with me initially for a particular purpose, namely loan 1. But now, my lord, when loan 1 is discharged, there is loan 2 which is due and outstanding, on which he has failed to make payment, on which I have initiated proceedings before the debt recovery tribunal in an original proceeding.
So in this 171, the material word is in the absence of the contract to the contrary.
Yes, there is no contract to the contrary.
That is the matter of construction.
My lord, if that's so, my lord, kindly see the impugned order. Does it even consider any of these things, my lord?
And in 148, the material words for our purpose is
the documents.
When the purpose is accomplished.
No, my lord, kindly.
That loan is repaid, purpose is accomplished.
My lord, 148, my lord.
Entirely.
My lord, 148 has to be read with 171.
Correct.
Normally, my lord, I would have to return it immediately after. But 171 says, notwithstanding the fact that I have a lien, as far as a banker, I have a general lien. When there are other monies that are outstanding, I can withhold it. Now, my lord, kindly see how the Supreme Court looks at it. Kindly look at, my lord, the judgment in Syndicate Bank versus Vijay Kumar. And my lord, there are many judgments of various high courts, all of which we have compiled together. But my lord, kindly see what the Honorable Supreme Court says. Can I request my lord has the Supreme Court? The question involved in this, my lord, page 5, my lord, page 5.
5-1.
My lord, running page 5, my lord. Page 5. Page 5.
Yes.
This is where the judgment begins. The question involved in this appeal is what is the meaning of banker's lien in the legal terminology and how it is understood and exercised in the banking system. The appellant is Syndicate Bank. The firm by the name of so and so has been enjoying various types of credit facilities from the appellant bank for the last so many years. They're also enjoying overdraft facility with a limit of 1 lakh. Then, my lord, with the limit of 1 lakh, hereinafter called a decree holder, obtained a decree against a judgment debtor for 1,04,000 rupees. In the course of the execution proceedings, the judgment debtor agreed to pay the decretal amount in the installment of 5,000, etc. I will not go into the facts of that case. May I request my lord to kindly skip this and come to, my lord, at page para 6 at page 7. My lord, here, my lord, for the purpose of issuing certain bank guarantees, an FDR had been placed. A fixed deposit had been placed. The bank guarantee stood discharged. The question was whether the fixed deposit money can be withdrawn, notwithstanding the banker's lien on the subject. Now, my lord, so kindly see section clause 6, para 6, my lord. The Honorable Supreme Court refers to some authorities on the subject, including Chitti on contract and so on. So then, my lord, may kindly look at page 8. Just after the second extract, my lord, the Honorable Supreme Court then says at placetum C, the above passages go to show that by mercantile system, the bank has a general lien over all forms of security or negotiable instruments deposited by or on behalf of customer in the ordinary course of banking business, and that the general lien is a valuable right of the banker, judicially recognized, and in the absence of an agreement to the contrary, a banker has a general lien over such securities or bills received from a customer in the ordinary course of business, and has a right to use the proceeds in respect of the balance that may be due from the customer by way of reduction of the customer's debit balance. Such a lien is also applicable to negotiable instruments, including FDRs. So, my lord, in that case, it was a fixed deposit receipt. Fixed deposit, he was saying, please, I am entitled to get back this fixed deposit because I gave it as a security for issuing a bank guarantee. Bank guarantee has to discharge. Now you're saying I will not release that money because there is a loan that is outstanding from me. So kindly see what the Honorable Supreme Court says. Such a lien is also applicable to negotiable instruments, including FDRs, which are remitted to the bank by the customer for the purpose of collection. There is no gainsaying that such a lien extends to FDRs also, which are deposited by the customer. Applying these principles to the case before us, we are of the view that undoubtedly the appellant bank has a lien over the two FDRs. In any event, the two letters executed by the judgment debtor on September so-and-so created a lien in favor of the appellant bank over the two FDRs, even otherwise having regard to the mercantile custom as judicially recognized. The banker has such a general lien over all forms of deposits or securities made by or on behalf of the customer in the ordinary course of banking business.
Here, what kind of dues are not paid?
Malad?
In your case,
Yes.
what are the dues? What kind of dues not paid? For which you are,
How much?
it is a loan or what?
Yes, my lord, loan.
Other loan.
Another loan. He has taken another loan in the name of his company. Much money. 6 crores, 89 lakhs. This was 1 crore. This was 97. Now there he owes us about 7 crores of rupees. He is the guarantor. His company has defaulted making payment. And here it was 1 crore.
Respondent is the company.
No, here the company is not responding. Here he files a writ petition in his personal capacity. He says, this loan I took alone. And now may I request Madam kindly also look at the impugned order. If Madam kindly looks at the prayer in the writ petition, which is at page 27 of the appeal memorandum. The prayer is to release the original documents to the custody of so-and-so in respect of this particular property. This is the prayer. Now, may I request Madam to kindly look at the impugned order at page 20. The order goes way beyond what he's asked for. In prayer A, it not only says return the documents within 1 week. In prayer 2, it says I will have no recourse to that property, even in respect of if ultimately debt recovery tribunal finds that money is due to me. In prayer 2, it says I can't proceed against this property at all, ever again. Liberty is reserved in favor of response 2 and 3 to prosecute proceedings initiated by them against the petitioner and others in relation to a different property other than the aforesaid property in accordance with law. And for all this, kindly see the reasoning. The reasoning is just one paragraph. There's no reasoning at all, no consideration of any of these things.
This appears to be justified that this is,
my lord,
the direction in 8C is beyond the prayer. That is right, but
no, but kindly also look at the reasoning. I'm placing, my lord, A, the contract between the parties says I am entitled to hold on to this.
We'll decide in the presence of other side. Notice written.
My lord, in the meanwhile, my lord, there's 1 week. My lord, I was given 1 week to return the document. But if I return the documents, nothing will be left in the writ appeal. My lord, I am not doing anything with the documents. I'm only keeping it with me. Kindly, if my lord stays the order, all that happens is I preserve the property. My lord, the contempt has been initiated by the other side. All that I'm saying is let the documents remain with me. I'm not going to do anything with the document.
Nobody prevents you from becoming adamant.
No, my lord, I'm only saying, my lord, kindly, my lord, pending consideration of the writ appeal. Let nothing.
I'm suggesting you understand.
My lord.
But we are not granting any stay.
No, but my lord, can I request that, my lord, after all, nothing will flow from it. It's a public sector bank. My lord, public money is involved. And my lord, if if he sells away the property, for example, tomorrow, my lord, we will have no recourse. Absolutely no recourse.
Nothing prevents you from keeping the documents in your own key and locker.
No, my lord, I can't. I have to return it because if the order is not stayed, if the impugned order is not stayed, I will have to return it. My lord, again, again, it will come up in another proceeding before, my lord, in a contempt.
May I do whatever you want to do with documents while we are issuing notice, but we are not granting stay. That's all.
No,
contempt is filed.
Yes, my lord. Contempt is filed.
From 13th. Not heard learned senior advocate Mr. So for the appellant bank, notice returnable on 20th February. Seeking interim stay of the directions issued by a single judge in the impugned judgment in order. It was submitted that the bank is facing a contempt proceedings. In this regard, it is observed that pendency of this appeal and issuance of notice therein will be a good defense for the bank. for the time being to counter the contempt proceedings.
Very well. Grateful. 28th, my lord, or 20th? I'm sorry, my lord.
20th.
Grateful, my lord. Grateful.
Seal number 18. With the Manisha Kangovi.
Query for the appellate. This is a matter pertaining to the validity of the advance pro rata charges that has been upheld by the learned single judge. And there are series of writ appeals filed on the challenges same.
There is a delay.
Please.
Delay.
There's a
Delay of 18 days.
Delay 12 days. Sir.
Notice returnable on 5th March.
And after matter is on 7th of March.
7th of.
7th of. Please. Much.
Seal number 19. Mr. DP Muttana.
Course, he has served, my lord, all the apparent, my lord. Sets of papers have been served. I request for short accommodation or reopening them
What is it? You on time?
next week.
Next week.
7 days delay is, it is there, madam.
Delay is there?
7 days.
7 days delay.
Maybe control, madam.
No delay. No delay. Delay.
There is no delay. I don't think there is any. Oh, sorry, madam. There is no delay. There appears to be no delay, madam.
No delay.
No delay. There is no delay.
No delay, madam. No delay, then.
Next week, any day, can I short accommodation?
When do you want?
Second week of.
Second week of
Second.
February.
1 week.
January. 23rd January.
Very great.
Seal number 20.
I beg to appear for appellant, my lord. In this case, my lord, though the land was restored prior to 2016, my lord, before passing the judgment of Nekkanti Ram Lakshmi, I am in possession of the land. Now, my lord, subsequent purchaser, the site purchaser, he has filed a writ petition before this honorable court and applying the Nekkanti Ram Lakshmi, then set aside the order passed by the Assistant Commissioner and DC, my lord, Deputy Commissioner. 2003 order passed by the Assistant Commissioner, 2009 passed by the Deputy Commissioner, both order questioned by the site holder, my lord. I have.
This can be, like notice returnable.
My humble request, my lord, stay the order, my lord, because by virtue of this order, my lord, filing several site holders, my lord.
Delay saved you only.
Please, my delay, my lord, only. RP I have filed.
Therefore, notice.
Please, my.
Otherwise, 16th year delay covered by that judgment. Notice returnable on 6th of March.
Please.
Seal number 21.
For the appellant's
Attorney.
the council is leading us.
So I appear for the appellant.
What is it about?
Before your lordships considers the passover, may just one word, my lords. I am seeking both my lord's notice at my lord's hands and an interim order.
It is all right, but
He's on his way.
My lords, I'll quickly, my lords, place the facts before your lordships, my lords. All that there are two writ appeals, my lords. Only one is posted before your lordships. The other one, I understand, my lords, is tentatively coming up on Friday. That's what I was indicated.
both may be posted together then.
Could we request then for Friday, my lord?
Writ appeal number 166.
Lord, I'm told the other matter may come up on Friday. Would your lordships consider? Would your lordships consider?
So
subject
this
to-
also give for Friday.
Please.
Friday, my lords, that's 1797 of 2024, please, my lords.
To be listed with writ appeal number 1797 of 2024.
Very good. Grateful.
I'm very grateful, my lords.
I think that solves my learned friend's problem also. Great.
That's great. Ready in notice matters, seal number 22. Says
State review petition to the government, my lord.
Review.
Lord, review petition to the government, my lord.
Against which order?
Lord, the order passed by this honorable court, my lord. Page number 27, my lord. The 11th paragraph is at page number 30, my lord. There was a direction to issue form number C, my lord, in respect of stone crusher's license, my lord. Lordship may kindly see on 29th August 23, my lord, an affidavit has been filed regarding the present status, my lord. Lordship may kindly see the memo, my lord.
29th August.
August 23, my lord, an affidavit has been filed.
This order is April.
Please.
Where is that
Ready.
affidavit? Where is that affidavit?
Lord, that has been filed on 29th August 23, my lord. Affidavit along with connected documents have been placed regarding the present status of the location of the property, my lord. The review is sought on the ground that the crusher unit, my lord, in respect of which license is sought, is situated less than 500 meters, my lord, from the waters and other things, my lord. There's a grant of land in favor of the battalion, my lord, Karnataka State Police Battalion. So a notice was caused, an inspection has been carried out, and an affidavit has been filed before the court along with relevant documents to show that it is less than 500 meters, my lord. The mahazar has been conducted. In addition, my lord, the Pollution Control Board has also issued closure notice here, my lord, insofar as the respondent is concerned. An order is passed by this court directing us to a positive mandamus has been issued for a grant of license, my lord.
So some inspection was carried out.
Please, my lord.
What made you to carry out inspection after the order?
My lord, there was an old direction for carrying out a spot inspection to ascertain the present status of the property.
Where is that direction?
Lord, we had,
On the contrary, the order of Learned Single records that everything was clear before.
my lord, that was before the authority, my lord. In
When
fact,
it is placed before the task force committee.
task force committee, my lord, that was based on an
The
assistant
matter was placed
commissioner's
before
report,
task
my
force
lord.
committee, all clearance was received.
All clearance were received, my lord. Thereafter, my lord, in the course of the review petition, my lord, and spot inspection was conducted, my lord, at the oral directions of this honorable court, my lord, during the proceedings. The review is being sought on the ground, two grounds, my lord. One is that the Pollution Control Board has now issued a closure notice. Now the question of issuing consent does not arise, my lord. They have not submitted any application seeking renewal of the consent license from the Pollution Control Board. Secondly, my lord, the location of the crusher unit, my lord, which is less than 500 meters from the school, my lord, and so also from the battalion for which the land has been allotted by the government, much prior to the act came into
That
force.
detail was not available with you when the petition was decided.
No, my lord, these informations were available, my lord, but the fact of the matter was that these documents have not been placed, my lord, especially the Pollution Control Board order, my lord. Along with the affidavit, my lord, those documents were now placed before the honorable court. There's a closure notice that has been issued.
So it is a ground of detection of subsequent fact.
Please, my lord. One is regarding the notice that has been issued by the Pollution Control Board, my lord. The unit has been ordered to be closed down because of various complaints received, my lord, especially because there are schools
Pollution
and
Control Board is party earlier, no.
it's not a party earlier, my lord.
Now the
Now
board has issued notice for.
Notice, my lord, the crusher
On the
unit has been directed to be closed down.
On the ground of?
On the ground that they have violated the consent and that complaints have been received from school as well as the neighboring residential areas, my lord. This
That's
unit is situated
the
less than,
Pollution control ground is different than the ground you are urging.
correct. My lord, that is an additional information, my lord. Even otherwise, the consent cannot be granted now for the reason that there is a closure order from the pollution control board also.
What is C form? C form is,
My lord, there is a license that is issued for the crusher, stone crusher unit, my lord.
it's a kind of,
That is a license permission, my
kind
lord.
of
granted.
license.
Please, my lord. The statute has come into force in 2011, my lord.
Notice written in one, heard learned edition.
Notice has been ordered, my lord.
Or who appears?
I'm appearing. Yes.
Why you are silent?
I'm sorry, my lord. Because when my learned friend was making submission, but I
If you are silent, then I will start dictating the word. Then argue, then what is it?
not think what my learned friend is making submission about affidavit and all that after review petition, not is not has not supplied to me, and all these things my lord he's making behind my back, all the spot inspection and the closure
Please
order
don't
and
clear.
all that he has obtained behind my back without bringing to my notice. Not I.
Not supplied the copy of your
I will place it, my lord. No, not they have not supplied. Supplied straight away.
supply code.
Sorry, my lord. Right away I'll do it.
And in the meantime, also find out a judgment. It is probably there. That a subsequent detection of fact
Please, my lord,
is a good ground of.
for seeking
Review.
review, my lord. Lords,
You have filed contempt?
sorry,
Contempt is filed?
no. They made me to wait. We are going to file writ appeal, sorry, SLP before Supreme Court. On that ground, I kept quiet. In the meantime, they have filed this review petition. After reviewing petition, they are delaying to issue the C form. Not I went on persuading the authorities by investing huge crores of rupees, installing machines. Machines were there on the land. Not 6 years, not the order is passed.
Sir Harish, who is instructing you? Pollution control board officer is instructing you.
No, my lord, there was a spot inspection that was conducted, my lord, during which time a notice was also issued to the,
Right now, who is instructing you?
from the office, the mines department.
Mines, not pollution.
No, not pollution, my lord. They were present during the
But
inspection, my
in
lord.
this review, there is another ground that pollution control board has directed closure of your unit. Is it correct?
I know instructions. But what my learned friend not filed affidavit, let him come, my lord, serve the copy. I'll go through it, I will get instructions.
How for?
Straight away will do it.
20th January. To supply copy of whatever
Publish right away.
even copy of the review.
That is being organized.
So still number 23, so state appeal, contempt.
There's a delay of 250 days, my lord.
After they have served notice in the contempt, belatedly they have filed an appeal.
Can I request for a passover of this matter, my lord, for 2:30?
You are for the sole respondent.
Sole respondent.
Delay can be condoned.
250 days delay is there, my lord.
As a belated, this thing after an afterthought, after contempt was filed and notice issued, they filed the writ appeal. Matter pertains to pension, of the respondent, who was a librarian and retired, he's drawing a meager pension of about 2,000 rupees now, age 75 years. So after the order of the learned single judgment, we gave notice to them and then waited and then were constrained to file.
Here is IA for delay.
But IA 1 of 24.
Of 24.
One of. Statement of objection is there, but where is IA?
But at page 100, not the appeal paper, not
IA for stay.
page 95, not perhaps.
Page there, yes.
95. After obtaining, my lord, they say an opinion in January. They waited till September, my lord, to file the appeal. Para 4, if your lordship sees.
Hard learned additional government advocate, Mr. Harish, for the applicant appellant, and learned senior advocate, Mr. So assisted by learned advocate. Give your appearance. We have the respondent. The present application is filed seeking condonation of due of 250 days, which has taken place in referring the appeal. Full stop. The appellant, appellant commissioner and education secretary, along with the other appellants who are the governmental authorities, they have stated in the supporting affidavit to explain the passage of time leading to delay from inter-alia that after the deliverance of the judgment and order of Lawrence single judge, opinion was sought forth from the government advocate, which was received on 19/1/24. Thereafter, the law department sent the communication to take steps to file the appeal. The matter was processed and the decision was finally taken to refer the appeal. The reasons furnished are in the nature of administrative process, since the appellant applicant is state authorities, from a consumption of time to some extent is inherent before final decision could be reached through the hierarchy of authorities. Element of culpability is not attributable. Sufficient cause is made out. Delay of 250 days is from the application is grateful. What about appeal?
My lord, any day convenient to the court, my lord, I'll go.
What is it about?
Matter pertains to pension, my lord, pay scale, my lord, of UGC pay scale, which was not extended. And therefore, not, it has a bearing on the pension of the respondent. UGC scales were not extended, not on the condition that she should obtain a master's degree. My lord.
Learned government advocate wants time. When shall we keep?
Any day convenient to the court.
Tell the date. February 4th.
Grateful.
Number 24, to A.V. Amarnathan.
I appear for the appellant.
Appearing for the respondent.
This is regarding electricity matter. My lord, what has happened is 2009, my lord, for 14 flats, the petitioner has taken connection. He applied for the connection, they sanctioned LT2. They only sanctioned LT2 from 2009. 2015, my lord, KERC declared this guest house as LT3 from 2015. Well, and as per the act, my lord, but they should intimate the consumer state in that from this day onwards, it is used as LT3. Without issuing any notice, then I'm using as LT3, and they issued a back billing for 6 lakhs and odd, my lord. I filed an appeal before appellate authority by depositing 50%. Now, it was 2015 appeal was filed, my lord. It was dismissed in 2020. Thereafter, my lord, they issued notice for 29 lakhs and odd, stating that back billing and all. My lord, the similar circumstances, the coordinate bench passed an order.
You are a developer or builder?
My lord?
You are a builder?
He's a
No, I had a factory, my lord, garment factory. For employees, I had this as a guest house.
Now, my lord, guest house is treated at LT3 category. Earlier, it was LT2 from 2009 onwards. When it is categorized as LT3, my lord, because the company has to intimate us that from this day onwards, we are charging LT3.
You're running a guest house.
We are guest house, my lord.
So therefore you ask for 14 meters.
Yes, my lord. My lord, the coordinate bench of the Honorable Court has stated that in such cases, the company has to issue notice. That was challenged in appeal, my lord. Appeal was disposed of, stating that the interest and back billing should be waived out. The regular payment has to be made. Can I pass on this appeal matter?
So guest house is commercial. Purple?
May I make?
Yes. What?
May I take my submission, my lord?
Yes.
I'm appearing for the respondent, my lord. Their contention before the writ petition as well as before this honorable court, my lord, they are using as the private guest house, my lord. My lords may kindly see the page number 473, volume 2, my lord.
So guest house will fall in residential?
No, my lord, they are using as the service apartment, my lord, which was published in the official website.
470?
473, my lord. My lords may kindly see the operative portion in 475, my lord, volume 2.
Tariff, accommodation type, single room.
Yes, my lord.
Should be
MK Paramount, my
one
lord.
bedroom.
Yes, my lord.
Bedroom.
This is using as a commercial purposes, my lord. It is very much available in all the travel websites, my lord. And
My lord, this is not available in website, my lord. My lord, I asked for the copy of them, my lord. They say they also doesn't have.
even
It is
today,
not available in the website, my lord. It is not available in the website. My lord,
my lord, even today.
my lord, even now, my lord, I have agreements for tenants. They are staying in that house. Now the company is closed, my lord. Because of the closure of the company, my lord, we have rented it out to houses, my lord. But after 14 flats, my lord, 2 flats I'm using it. 12 flats I have rented it out. I have got agreements of rented from past 2015. All the tenants are staying there. It's not that used as a service, apartment or something like that, my lord. It's only they use this as a tenants are staying there. Well, it is used as a residential only, it's not non-residential.
Even, my lord, after disposal of the writ petition,
The assistant engineer inspects, my lord, that is under section 126 of Electricity Act, he should inspect by issuing notice. No notice, he comes and inspects and reports that this website and it is used as commercial. My lord, they are not followed the regulations, what is provided in section 126 of Electricity Act. My last time I can take to section 126 of Electricity Act, my lord. 126 of the Electricity Act.
Page 963.
Pardon me. And I have the regulation, Karnataka Electricity Regulation Commission, I have regulations, my lord, and the regulation 42 also, 42.07 of the regulation also, it provides for how it should be inspected. I'm sorry, my electricity.
Lord, I'll make a submission, my lord. On 42.2, misuse of tariff, they have raised the demand, my lord. The demand notice will be found in volume number 3, page 635, my lord. And the petitioner has given the reply to the demand notice, which will be reflecting in volume number 3, page 694, my lord. Demand notice was raised, my lord, 42.2, my lord. Demand notice was raised. My lords may kindly see the volume number 3, my lord.
Page number?
Page number 635 is the demand notice, my lord. Reply is on 694, my lord.
Lord, from 2050, only tenants are staying. There's no commercial utilization of that.
First page of the
Inspection, my lord, they did not provide the proper notice for inspection also, my lord. And as soon as it comes and inspection reports, based on that report, all
they
this
have
packet.
given the reply, my lord, which will be found in 694 for a demand notice.
694.
Yes, my lord. On 15th June 2015, my lord, the demand notice is issued on 29/4/2015, my lord.
624, I filed my objection stating that I'm not using it as a commercial.
Objections against the demand notice, their subject itself is says, my lord. We have issued the notice, and for that demand notice, they have given the reply also. They have appeared before the appellate authority. They admitted that the premises used for the private guest house, my lord. Even private guest house comes under LT3 only, my lord. The tariff order which will be reflecting in volume number 2, 457, my lord.
LT3 comes on to 15 onwards, madam. KSE declared this guest house as the.
My lords may kindly see the tariff order which will be found in volume number 2, 457, my lord.
What you are showing from 457?
Tariff order, my lord. Operative portion is, my lord, on 465, my lord.
465.
Tariff scheduled LT3, item number 8, private guest house, my lord.
Like comes from 2/3
Item number
2015.
460.
It is effective from 2015 onwards.
Item number 8, my lord. My lord, where he himself admits before the appellate authority, which will be found in page number 704, volume number 3, my lord. It is a private guest house. He himself admits that, my lord.
Like it declared as LT3 from 2/3/2015, page number 457 is very clear. That's what I'm mentioning, Miller. From 2/3/2015, it is declared as LT3. Earlier it was LT2. They only give the bill for LT2 from 2009 onwards.
Operative portion is 707, my lord, page number 707. Volume number 3, 704, appellate order found, my lord.
Third learned, you are Mr. A.V. Amarnathan?
A.V. Amarnathan.
Third learned advocate, Mr. A.V. Amarnathan for the appellant and learned advocate.
I'm appearing for the Padma Uttur, my lord.
Padma?
Uttur, UTTUR.
Give the, for the respondent. This appeal under section 4 of the Karnataka High Court Act 1961 is referred by the original petitioner against
I make one submission, my lord. I can produce the rent agreement of 12 tenants. They are staying there in that house, my lord. 12 tenants.
My lord, it is available in the website, my lord.
My lord, I asked for the copy. They did not provide me the copy. I searched in the website. It's not available.
Judgment and order dated 6th August 2024, passed by learned single judge, whereby the petition of the appellant as petitioner came to be dismissed. In the original petition, the petitioner challenged 14 demand notices dated 29/4/15 issued by respondent number 1, the assistant executive engineer into the electrical. Whereby the electric connection given to the petitioner's property was converted from LT2 to LT3, and the billing was accordingly modified for the period concerned. Also prayed was to set aside the order dated 23/3/2020, passed by the appellate authority. Respondent to hearing. The petitioner had obtained 14 different connections with different RR numbers in the category of LT2. Which was the connection for use of residential purpose. The case put forward by the petitioner in the petition was inter-alia that the property oblique apartment was exclusively used for his employees, and petitioner had not been charging anything from the employees. It was stated by the petitioner that the petitioner was not using the building for any commercial purpose. It appears that respondent number 1 authority sent 14 demand notices dated 29/4/15 with a covering letter dated 29/4/15 against all the 14 RRs, whereby the connection in the category LT2, LT-2 into bracket small a, tariff schedule 2, LT3 was converted to LT3, LT-3 tariff schedule. In other words, the connections were treated for commercial purpose instead of residential purpose. The case of the petitioner was, however, that he was using the building for residential purpose only. Paragraph. Learned single judge, while dismissing the petition, considered the aspects that the petitioner had the opportunity to file objections to the demand notices. He was furnished inspection reports which showed that the building was used for commercial purpose. Not only that, the petitioner had filed appeal against the decision of the competent authority pursuant to the demand notices. And the appellate authority had come to, and the appellate authority came to the conclusion that the petitioner was running a commercial enterprise in the premises. A finding was recorded that the said factum was clear from the display board also, which was found outside the guest house. In course of the hearing, learned advocate for the respondent took the court to the relevant documents which were before a single judge. They included the website portal
Yes, my lord.
of the
.com, my lord, and
petitioner, which reflected the details of tariff which was being charged by the petitioner for use of the various apartments in the building. The tariff were fixed for single studio room, 1-bedroom apartment, 2-bedroom apartment, 3-bedroom apartment, for night basis, and on the basis of the number of occupants. Full stop. The appellate authority also recorded a finding of fact that the use of the building was for commercial purpose by charging the tariff from the occupants. The case of the petitioner that the employees were given accommodation stood negative on facts. Learned single judge endorsed to the finding recorded by the appellate authority. Full stop. In the aforesaid review, when the finding of fact was reached by the competent authorities, including learned single judge, that the property was used for commercial purpose, the action on part of the respondents in converting the category from LT2 to LT3 could hardly be ported. Full stop. The tariff schedule of LT3 includes the private guest house,
yes,
which are treated for commercial
yes,
purpose.
ma'am.
Full stop. In the aforesaid view, no error could be booked in the judgment and order of learned single judge. The appeal is meritless and the same is dismissed.
Much obliged.
This is number 25, CPL, Sharon Desai, 14%.
My lord, this matter is regarding the illegal encroachment of Gulbarga Fort.
They have filed reply 2018. What survey now? That now some encroachment in some archaeological site.
Please, my lord, please, my lord.
So what was that site?
This is a fort, Gulbarga Fort, my lord.
Fort.
Declared as a national monument, my lord. So there is a protected area which is inside the fort. There are 282 structures existing, my lord. Outside the fort, 62 and 114 prohibited area and regulated area. Total 160, 176 structures outside and 282 inside, my lord. And the order has been issued in 8 November 2019 to demolish all the structures, my lord. It's only because the state is coming before this honorable court requesting for 2 weeks time since 2019, my lord, to rehabilitate them outside the fort. There is no provision in the act for rehabilitation, my lord. And if we allow these illegal structures to exist in another 2-3 years, the city bus will start going inside, my lord. There's some more education institution, everything. They're going to destroy the entire fort, my lord. This is one of the most national importance of this. And one more, there is a graveyard inside the fort, my lord. Graveyard. Graveyard exists inside the fort for those 284 people, whoever dies, they bury inside the fort, my lord.
This Gulbarga fort is where, situated where?
Gulbarga. Gulbarga, my
In
lord.
Gulbarga only.
Kalburgi. Kalburgi.
It was renamed as Kalburgi, my lord.
Who appears for commissioner?
But I appear for the Gulbarga Corporation. But the direction is not issued to the archaeological department to remove the structures with the help of the regional commissioner and the deputy commissioner. This order was made on 8/11/2019. 8/11
was filed in the 2019.
19, Lord.
And there are 282 encroachers are identified. 140 inhabitants were issued notice.
That's in the
by-
regulated area, my lord, and 62 in the prohibited area, so
Prohibited
outside the fort.
Lord,
There are restaurants, residents outside the fort, my lord, 176 structures. At least they could remove those structures actually, but their reasoning is only 282 structures should be.
My lord, may make one sir. Is it now shops have occupied the entire area?
Please, my lord. 282 demolition orders were issued to the violators, my lord, in the protected area. Lord, after that, my lord, under section 19(2) of the Archaeological Act, my lord. Now, my lord, after the order passed 8/11/2019, there was an order by this honorable court to the deputy commissioner for demolition and I'm sorry, my lord, if your lordship might and to 8/11/2019, the order sheet, my lord. 8/11/2019, my lord. May I read it out? May I read it out?
It's a fort,
Yes,
It's
my
a
lord.
fort.
so bound by the wall. And inside there is a shop.
These,
Inside the wall.
Inside the fort is called
inside the
protected
fort.
area, my lord. There are
Protected,
282.
floods, protected area, regulated area and prohibited area. These 282 violators are in the protected area.
So nothing is happening.
Nothing has happened, my lord, since 2019, my lord. Every time the state come before the court, they ask for 2 weeks time for rehabilitation of those.
You don't have powers to
No, my lord, it is for the deputy commissioner to do it. The reason is this, my lord. I would differ from my learned friend. The reason is this, my lord. It's not that every time the state has taken time, my lord. The state did something. My lord, they came up with the,
No, why should you defend the state?
no, I'm just bringing it to your lordship's
Why should
notice.
you?
I'm just, my lord,
My lord, the
they
only
proposed-
reason,
they
reason the state want to do is rehabilitate them.
I am
because
not-
There is no, there is no clause
I'm
in the
not-
act, my lord. There is no
Sir,
rehabilitation, my lord.
I'm not defending the state, my lord. They came up with the proposed constructions for 283 houses for rehabilitation for dwellers at the fort. They wrote us a letter that please give us some funds of rupees 37 crores.
That is
for-
between you and.
Please, my lord. Now what happened, my lord, the submissions was made by them on 8/8/2024. We have said that, my lord, there is no such provision to give the funds for rehabilitation of the violators. This is, I have placed it on record, my lord. Because the state may say that we have requested the,
After this order dated 8/11/19 compliance report is filed,
no, my lord.
No, my lord. No, my lord.
then we'll call the commissioner.
Please.
Why you are not complained?
Madam.
Who appears?
My lord, we have filed an affidavit, my lord. My lord, but
Compliance report is not the affidavit. Compliance report is the compliance report.
Yes, my lord. No implementation of the order, my lord.
my lord, then could I seek for
4
some
years so
time?
far.
No, my lord.
Not that, it's a matter of 15 days.
No,
or
no,
few months.
no. My lord, but my lord, we have to right or wrong, we are a welfare state, my lord. We'll have to rehabilitate 283 encroachers. My lord, for that,
They are the shop holders, not the residential.
My lord,
there are houses also, my lord.
Houses also.
my lord,
Yes,
entire village
and
is
they don't
existing, not
have
only the houses, my lord.
documents, my lord. That's the problem. That's the reason
Entire
why we
village.
are trying to rehabilitate them. Now, to rehabilitate them, my lord, we need funds. And the funds, my lord, is 37 crores. My lord, it is a centrally protected monument. My lord, we have to work in tandem with the, my lord, central government to see that, my lord, these people are not deprived of even a shelter. 283 encroachers, and there's going to be a law and order problem once it is.
My lord, all of these encroachers are given 3 show cause notice, my lord, 3 times. They've been issued with 3 show cause notice, my lord. Nothing has happened.
My lord, question of just evicting them will not solve any problem, my lord. We have to see it from a humanitarian side. My lord, may I request for some time so that I could have deliberations and then get back to my lord, my lord.
Insofar as insofar as Union of India is concerned, my lord, we have made it very clear to them that there is no such provision for rehabilitation, and we are not going to assist them in the rehabilitation. It is for there's no such provision.
There's no such provision in the act.
Because they
for
themselves
rehabilitation.
requested us.
Everything
Now,
comes-
my learned friend may say that we have requested the Union of India. Therefore, my lord, we have made it clear on 8/8/2024 to the Deputy Commissioner by writing a letter that, my lord, there is no such provision for assisting them for the rehabilitation.
My lord, everything comes at a cost, my lord. Nothing comes free, my lord. But that doesn't mean they cannot assist us, my lord, in the expenses that will be incurred to rehabilitate these 283, my lord, persons.
If your lordship may kindly turn to the Rule 38 of the Ancient Monument and Archaeological Site, it makes very clear, my lord, removal of unauthorized building is by the Deputy Commissioner.
My lord, we don't dispute that, my lord, but the cost, my lord, the cost, and they have to be rehabilitated. It's a law and order problem. It's not a trivial, my lord, problem where it can be resolved.
Lord, for removal of unauthorized buildings, we're not supposed to pay the cost for them. I don't understand.
My lord, that they should have said before, not as an afterthought and not when I'm bringing it to the notice of my lord, the difficulties that the government is going to face.
Lord, it's a
My
bond
lord, we have to do it in collaboration, considering it is a humanitarian problem. That's why I said, my lord may grant me some time so that I could get in touch with the learned advocate general and see how it can be resolved, my lord.
Yes, my lord. They're all labor.
Houses. My lord, there are houses.
My lord, in the PT,
if your lordship may kindly turn to
page number 27.
29 and
20
onwards, my lord.
24, my lord.
Of the petition, page 24 onwards. No, my lord, the list of illegal occupants and residents
illegal encroachers are
inside the fort, page 24, my lord.
24. 24. 24 to 29, my lord.
Please, of the petition, my lord. As on 6/5/2011 is the list, my lord. If your lordship may kindly turn to further pages of Annexure E and G.
Yes, my lord.
House number. House.
My lord, and then there are some.
The Deputy Commissioner.
The archaeological department, my lord.
Archaeological department has not given.
Because they are the owner of the monument, my lord.
We're the owner. Lord, there are some illegal constructions which have been done.
My lord, exact this thing, I don't have immediate information to inform my lord.
My lord, if you see the annexure B on page number 20,
18.
my lord.
No, my lord, they are old. 40, yes.
1998, my lord.
45 years old.
For a moment.
50. My lord, may see even some of the structures inside page 30.
Please, my lord. Lord, this was declared, my lord.
My lord, kindly see annexure A, page number 19, my lord.
That, my lord, I'll.
No, exact date is not
With
given,
that
my
date.
lord. That has to be verified.
But prior to 2011, my lord. Lord, we have issued notice. We have issued notice to them
Please
and
show
we have,
cause notice.
Lord, this
During the
notice was-
proceedings, my lord, during the court proceedings, during the PIL proceedings,
No, prior to that also we have issued notice, my lord. I have placed it on record, those things. My lord, the second thing is that, my lord, we have, as and when brought to the notice of the deputy commissioner also, this is an encroach, these are illegal structures. All those things is brought to the notice of the deputy commissioner.
My lord, let them not blame only the deputy commissioner, my lord. My lord may have this after 2 weeks and I'll get information. Everything, it is only the state. They wash their hands off.
my lord,
Nothing comes free, my lord.
my lord,
Pardon me, my lord?
the state.
No, my lord. I'm sorry. No, my lord, every time it is the government, every time it is, I understand we are there, we play a part, but not every time, my lord.
My lord, Annexure B2, page number 20, my lord, the deputy commissioner, the archaeological department has been sent a letter to deputy commissioner listing the same problem that you have to remove the illegal encroachment, my lord. So far, nothing has been happened. So many letters have been exchanged between the archaeological department and the state, my lord.
My lord, I apologize, my lord, if I have raised. Sorry. No, I didn't mean to, but I don't know, my lord, it's just. No, I'll place everything before my lord, and my lord may take appropriate action.
Yes, my lord. I produce the photographs also, my lord.
We are maintaining it. Then, so far as the fort, my lord, it is. My lord, it is 1347 to 1527 AD. This was a fort of the Bahmani Sultanate.
Varangal dynasty.
The better photograph is it?
My lord, 2 weeks time, my lord. No, my lord, what is the actual ground reality as on date and what we intend to do? My lord may grant me. My lord, I appear for respondents 2 and 3. The regional commissioner and the deputy commissioner revenue.
But I am for the respond number 4, corporation note.
November 8.
Annexure B. Annexure B, page 20. Please. Fourteen 12/1998, my lord. With my lord's permission, my lord, to interrupt, to interrupt with my lord's permission. If your lordship may, 4/3/2020 in the order, my lord, paras 6, my lord, is there that, my lord, the government advocate has sought time to rehabilitate and they've sought 6 months time, my lord, in the order. I'm sorry, my lord, to interrupt.
Yes, my lord. My lord, it's not the scheme,
lord,
but
the-
3 acres
My
of
lord,
land.
my submission is no scheme is provided. There is nothing, not even a single stone is moved from the fort, my lord. Yes, my lord.
Two and three and. My lord, regional commissioner. 2. No, my lord, because 283. My lord, 283 encroaches, my lord. 283, we wouldn't want them to go shelterless, so that is what is
Lord,
weighing in our mind.
on please. Lord, on 4/3/2020.
There might be a law and order
Well-
problem, that is what scared.
My lord, on 4/3/2020.
No, not that, my lord,
My lord, if they would have solved this problem in 1998, they wouldn't, why I should not be standing here before you, my lord. They just giving excuse, the letter is exchanged between the
Yes.
Yes, my lord.
I'm obliged, man. I'm obliged.
Lord, on the,
You,
please.
I'm
All
obliged.
that I am bringing to your lordship's notice is this. Please. Lord, even then, my lord, there's an order in para number 7. 6 months time is granted. That is the part of the order on 4/3/2020 itself. 4/3/2020. If you
Lord, let him not rub salt
no,
on
I'm just
the
bringing
my
to your
lord.
lordship's notice, my lord. That apart, I will not. 4/3/2020, my lord. Please, my lord. The para number 7, considering the facts that large number of families are involved in the state and the state process to rehabilitate them, we grant them 6 months to the state government. 4/3/2020, my lord. That is after 8/11, my lord. That order is there, my lord.
Seven. Seven.
Please, para 6, my lord. I'll straight away take your lordships to para 6. We have perused the memo dated 4th March 2020 submitted by so and so. We accept the statement made therein, the statement made by the state government and the Deputy Commissioner Kalburgi. It is stated in the memo that arrangements are being made to provide alternative accommodation to 282 families, and therefore time of 6 months may be granted to move the said 282 families. Considering the fact that large number of families are involved and the state process proposes to rehabilitate them, we grant them 6 months time to the state.
My lord, based on our memo, my lord, that was filed on 4/3. My lord, I didn't get.
Please.
Much obliged.
Obliged. Lord, could I have a copy of this order so that I can oblige, my lord?
Deputy Solicitor. Shanti Bhushan. Shanti Bhushan. Great.
Oblige.
26 is urgent. Seal number 27.
Please, my lords, I appear for the petitioner, my lords. This pertains to the Anganwadi, my lords, where the water is getting contaminated. Despite, my lord, the order being, your lordships being pleased to order for notice. A year ago, my lords, no action has been taken. 500 students, my lord, who are in the Anganwadi, my lords, government school, they are in serious trouble, my lords.
My lord, in this, may I request my lords to, my lord, the pollution control board to be made a party, my lord, because this is due to, my lord, loading and unloading of chemical fertilizers, my lord, in a godown which is just adjacent to the building and which is causing pollution to the borewell, my lord, which supplies water to the children and to the villagers.
The only source of water, drinking water to the entire village, my lords. And the midday meals, my lord, is prepared, my lords, using this water. It's affecting about 500 students, my lord.
Lord, Mr. Mahesh Chaudhary is here, so if my lord could. Yes, adjacent to the school. And because of the loading and unloading, my lord, of those fertilizers, my lord, there's a lot of dust. And my lord, which settles on the ground, my lord, and which is seeping into the bowel, which is the only source of drinking water. My lord, Mahesh Chaudhary may be directed to take notice, my lord. He may be able to help us resolve this issue. Oh, that is not informed, my lord. My lord, the godown
I'm
has come
sorry,
up
my lords, your
recently.
lordships are not audible, my lord. I'm extremely sorry to make that mention, lords.
The go down is prior in point of time or school is prior in point of time?
45 years the school has been functioning, my lord. 7 years ago, my lord, this fertilizer industry, my lord, it is established.
So after school is earlier.
Earlier, my lords, 45 years, my lords.
But then who permitted this fertilizer go down to come up near the school?
That is a state my learned friend has to, my lord, answer.
Lord, it is a panchayat, my lord, and now
This is
even
Anganwadi center.
Anganwadi center, please, my lords.
And there must be cooking also.
yes, yes.
Cooking, midday meals is happening, my lords, using the same water, my lords.
This is also real public interest.
Yes, yes. My lord, let him take notice, my lord, and he may be able to initiate action against the godown, and then the issue might
In
be
the
resolved.
interregnum, my lords, I would require some facility, my lords. Otherwise, my lord, in the long term, my lords, it's affecting the health of the entire village, more particularly the students. And notice was ordered almost more than a year ago. No action has been taken till date, my lords.
That will have to wait. They are all supporting this chemical fertilizer. No, no, I want them to. You shall act in the presence of these. Could I make one submission? Inspections have been conducted.
Yes, Mr. Counsel, how it affects the functioning of the school or the health of the children?
My lord, what is happening is this fertilizer, my lord, the loading and unloading happens in the godown throughout the day, my lords. For every 30 minutes, my lord, it keeps happening. And when these
The moment the bags are dumped in the center.
This is underground?
No.
No, my lords, it is on the ground level itself, my lords. When what happens is when the loading and unloading happens, my lord, this urea, my lords, falls on the ground, my lords. Finally, it accumulates, my lord. It goes to the ground level, and it is a bore well, and it is getting accumulated, my lords. By virtue of that, my lords, it's deteriorating, my lords, the health of the students, and that is the only source of water for the entire village, and the village consists.
Council, listen. What
Please,
he has stated in the writ petition is that it is a bore well.
Please, my lords.
It is not an open tank. It is not a well.
Please, my lords.
Bore well, it is, what do you say? The water comes from underground actually.
Underground, my lords.
Below the ground. We
Please,
are
my
not
lords.
stated how a mere go down, existence of a go down.
Yes.
The effluents are discharged into an underground water and how it is contaminated. See, if it's open well, we can understand there is a lot of dust and other things, urea, other things over there, which invariably falls into the open well or the lake. It is washed into the open well or the lake and it is contaminated. We can understand. When it is a bore well, mister, the water is coming from under the ground. When you pump it, it comes out. Where is the question of underground water source being contaminated by urea, the dust of the urea on the ground?
My lords, gradually, my lord, this seeps down to the ground, my lords. And by virtue of that, my lords, it's happening. I understand. I totally understand, my lords. It's not a well. It's not a tank. There is no direct, my lords, direct way where it is causing problem. But apparently, my lords, once it goes down, my lord, it's seeping down gradually. And there's a lot of dust, my lords. The loading and unloading, the portion of it falls on the ground. And gradually, my lords, that seeps down. And by virtue of that, my lords, it's causing, my lords. This I have stated, my lords, in my pleading.
My lord, may I make a submission, my lord?
Yes.
My lords, in this
You are for
respondent, my lords, I am for, my lords, what has happened is the petitioner has made one respondent number 10, my lords. He calls it by a certain name, Ganga Kaveri, so and so. There is no such company by that name in that place, my lord. Unfortunately, even the person named there, Mahesh, so and so representative, is actually Mahendra, my lords, and it has got served. Now, may I just state what the facts are, my lords? There is no such company by the name, but it is a fact that there is a warehousing, my lords, of several public sector units which have also been given leases, which are fertilizer companies, as well as private fertilizer companies. This is only a storage space, my lords. There is no manufacturing happening. There is no production of any sort happening. The issue that the petitioner is raising is of grave concern. We do not want to get into a litigative mode here, my lords. There is underground water contamination which is there in the area, which is a serious matter. My lords, the reason why this is happening is in and around that entire place, there is large sugarcane fields, my lord. And even we are also suffering from the contaminated water because the storage of molasses over a long period of time.
You are for number 10.
Please, my lords, 10 is wrongly mentioned as a company, but there are several companies, fertilizer companies, who all share the common warehousing corporation. Universal Care Warehousing Corporation is the main lessor, who has given it to several fertilizer companies for storage purpose only. There is no contamination possible from the fertilizer because there is no manufacturing happening. It is not even the case that my lords, I want to find my details. Let
Before
them
that, my
make
lords,
the
if I
proper
may
parties
interrupt, my
as
lords,
the. Let me
there is
just
a
complete.
sample testing which is happening, which has happened, my lords. And it is
Yes.
already placed on record, my lords. If your lordships are pleased to come to page 133, my lords, and the translated version, my lords would find it at page 134. I may be permitted to read, my lords. It is to the Assistant Executive Engineer, my lords, and the PDO, my lords, of the village panchayat has sent this letter, my lords. I may be permitted to read, my lords. With reference to the above captioned subject, quality standard of drinking water sample in the residential area within Hubbaravadi village panchayat jurisdiction of Raibagh Taluk, so and so subdivision has been tested. Water has been polluted, contains turbidity, taste problem. Hence, we hereby request you to your kind authority to solve the problem and facilitate drinking water to the general public of the village and school children, and also facilitate the education of the children. This is not my report, my lords. It is already on record, my lords, that the sample testing shows that the water is contaminated. It is not, my lords.
I am not joining issue with this at all. I straight away consider there is underground contamination. It is happening because of a larger reason. It is nothing to do with storage. My lords, godowns can never pollute by mere storage.
Your
One
lordships,
can
my
understand.
lords, if I may request, my lords, appoint a commissioner, my lords, let a report be, my lords, placed before your lordships.
There are public sector responsible units
May
also
I
in part
request
of the
for that,
same
my
godown.
lords? Now we are not on the issue, my lords, who is contaminating the water, but apparently, my lords, in reality, it's a contaminated water.
True.
Some workaround has to be brought in, my lords. That is all is my request, my lords, before your lordships.
The petitioner herein happens to be a resident of the Puravadi village. The issue sought to be espoused by filing this public interest petition is that there is a government primary school, which is also a Anganwadi center located at the village. It is the case that nearby the school, there exists a chemical fertilizers godown. It is the case that in the godown, the activity of loading and unloading of chemical fertilizer bags continues, due to which the chemical dust emanates from the bags and spreads around the area which is adjacent to the school compound. It is the further case of the petitioner that the chemical used in the process sinks inside the earth, and as a result, the borewell water gets contaminated. Paragraph. It is the further averment made in the petition that every day the laborers who wash the lorries and trucks used to take bath in the open field from a water with chemical dust drowns into the earth, and that also leads to the contamination of the borewell water. The borewell water, it is stated, is the only source of drinking water to village as well as the school and Anganwadi centers, students, children. Anganwadi centers, children. It is stated that thus the entire effect is on the health of the children and the villages. The prayer is therefore made to direct the respondents to take appropriate steps. In course of the hearing, from a learned additional government advocates, Srimati Neelofar Akbar would submit that having regard to the nature of the allegations and the subject matter involved from the Karnataka State Pollution Control Board would be a proper and necessary party whose stand would facilitate the court in arriving at a proper adjudication. Full stop. In that view, learned advocate for the petitioner, Mr. So-and-so, requests the court to permit to implead Karnataka State Pollution Control Board through its chairman as party respondent 11. Learned advocate Mr. Mahesh Chaudhary, who is present in the court, accepts the notice on behalf of his one, from which notice is hereby issued, returnable on 30th January. Full stop. Looking to the nature of the grievance raised in this petition, it is directed that respondent 11 Pollution Control Board shall constitute a team of 3 members, whom shall include also the executive engineer, Department of Rural Water Supply and Rural Water Supply. Which is the authority? Or Chikkodi?
Chikkodi, Mala.
Chikkodi. Make a higher officer a party.
Mala, respondent number 2, executive engineer.
2, executive engineer.
Yes. Mala, then the Tahsildar, Mala, the
6.
Department of 4-member team, whom shall include the 2 officers appointed from the Pollution Control Board. 1 to be the executive engineer, Department of Rural Water Supply, Chikkodi, as well as the Tehsildar of the Belgavi, Tehsildar of the Raibag Taluka. The team shall visit the site, shall examine the aspects in light of the allegations made in the petition. And after conducting the survey and the study, shall furnish a report to the court to the alleged effect of the fertilizer go down from loading and unloading of the fertilizers.
For the nature of the pollution caused. For the
And
nature
the-
of the
and
pollution caused,
and the pollution caused
if any.
thereby, as well as the effect on the functioning of the school, as well as its repercussion in the function of school, as well as effect on the human health. Full stop. The report shall also indicate whether these activities results into the contamination of the water, underground water, which is used by the school, public Anganwadi children and the villagers. Such report shall be filed before the next date.
That's my request.
Request for a date, my lords.
Date is given 17th of 30th.
So grateful.
Will need little more time you want?
No.
We don't.
It is enough.
That's one request is that that's the board, that committee methods that may be mentioned as it is headed by the senior environmental officer. So that it,
4-member committee headed by the senior environment commissioner
officer, SCO,
of the
pollution control.
Pollution Control Board, which shall include another member drawn from the board.
That it is automatically because the senior would include RO and
Very
deputy RO.
My lord, could I make one request? My lord, let it be the chief engineer, my lord, not the engineer, the chief engineer.
So the headed by so and so, and which will consist,
Chief engineer.
in addition, the chief engineer,
Department of Rural Water Supply.
Department of Rural Water Supply,
And Tahsildar.
comma,
No, I'm obliged.
and Tehsildar.
Tahsildar
So
of
two
Raipur.
officers from board, chief engineer and Tehsildar of the Raipur, Raigad, whatever.
Raipur.
Yes, ma'am.
So grateful.
Great.
Obliged, my lord.
28 is urgent. Number 29. Sir Ravindra Gajanan Kolle.
Please, my lords, herein I may be granted some time, my lords. I will prepare a comparative chart, my lords.
When do you want? February?
Anytime, my lords.
Whenever you prepare chart, 10th February,
Please, my lords.
at the request of learned college, 10 over to 10th February.
30 is urgent. Number 31. Sir Ganapati Bhatt.
There is short accommodation in this matter, my lord. There is short accommodation in this
Time, all right, 11th February, as requested by learned petitioner.
Yes, sir. Number 32.
My
Mr.
lord.
Ramesh Nayak, L party in person.
My lord, in
Sir,
this,
PA.
I pray for 2 weeks' time, my lord. It pertains to contamination of water. My lord, I have to receive some more response, my lord. My lord.
The petitioner party in person is not present, learned additional government advocate from the Nilofer Akbar wants time to take instructions, 10 over to 17th February.
Obliged.
Number 30.
For the petitioner,
Chandan Gaspar.
respondents have served the statement of objections today. So I'll
Which
just.
one?
We just filed, my
33.
lord, in the counter.
33.
Yeah, yeah. Respond number 6. On behalf of respond number 6, SO has been filed,
So
counter.
you want time?
Please, my lord.
Learned advocate Ms. so and so wants time on the ground that the counter is filed today.
Please, my lord. I mean, February 3rd.
10 over to which February?
Feb.
10 over to 13th February as requested.
Great.
Yes, next. 34 is urgent.
34 is urgent. Number 35. Sir PA. Sir Ravi Kumar GH. 35.
Lord, in this matter, petitioner is seeking direction as to respond number 1 to 4 to remove the illegal construction and encroachment made by the respond number 5 in government land. Lord, page number 24 is RTC. It is in, my lord, Kaniyuru village, Beltangadi Taluk, my lord. In that, in survey number 27/1A, my lord, there is 11 acre, 11 acres of land is there, my lord. 13.68 cents of land is there. In that land, my lord, respond number 5 has illegally encroached and started the.
What is the encroachment? Illegal construction, stop the number 5. Who is number 5?
My lord, they have
Some
constructed a shed in the government land to celebrate a festival Ganesh Chaturthi.
Pardon?
They have constructed a shed in the government land for celebration of
You go before them, they will, you consider.
mandamus, my lord,
Ma'am.
seeking for.
So you will ask them to make a representative, you consider it.
You are
Within
given,
two- Nothing more, disposal.
you are given the representation, my lord. And
You have given, then they will consider. Like,
MNP,
it is not decided.
no, my lord.
no. And there is a report of the subordinate officer, my lord. There
Where
is,
is the representation?
sorry, my lord.
Where is the representation?
representation is, madam, page
This
number.
is semi pakka construction. It appears
Yes, if I could remove it, my
to
lord.
be removed.
There is a subordinate officer report, my lord. There is a revenue inspector report in page number 38, my lord. Initially they have started for construction of the auditorium. Page number 40 is a translation copy of version, my lord. After receiving our representation, my lord, Ashildar has directed the revenue inspector to submit the report, my lord. Accordingly, my lord, they have conducted spot master and submitted.
Third learned advocate, Mr. So-and-so, so-and-so, for petitioner, learned additional government advocate, Srimati Neelofer Akbar. Notice is issued
Yes, my lord.
upon
One-
service of notice issued by the court. Full stop. Claiming to be a public interest, public spirited person and projecting to be a social activist, the petitioner has filed this petition in the nature of styling as a public interest petition, seeking a direction against the respondent 1 to 4 authorities to recover the government land by removing the unauthorized construction allegedly made by respondent 5 trust. The case inter-alia paragraph of the petitioner is that the land survey number 27/1 of capital A, had measuring 11 acres and 19 cents, which is government land at Kaniyuru village, Kokkada Hobli, Belathagandi Taluka, DK district, has to its adjacent, a playground in survey number 265/1A1, at measuring 1 acre and 83 cents. It is the case that with a malified intention, respondent 5 trust and its office bearers have encroached upon the said land where there is a playground and have started construction. It is stated that though petitioner has given a complaint to the authorities, no action is taken. Paragraph. From the averments in the petition, it transpires that the representation of the petitioner dated 14/9/24 is already made, requesting authorities to take steps to stop the alleged illegal construction by respondent 5. Full stop. The said representation is not attended to. It is further alleged. Paragraph. Learned additional government advocate.
Lord, could I just produce these?
Would submit from the record of the petition, including the photograph figuring at Annexer C into bracket page 30 and Annexer D into bracket Annexer D, that the construction sought to be complained of is not a pakka construction, and if the encroachment is found, and if the construction is found in the nature of encroachment, the authorities can always require the.
Lord, could I make one submission? I'm sorry. My lord, a notice has been issued, my lord, to the Panchayat Development Officer to take possession of this, my lord, construction.
It is not a pakka construction. She
Yeah.
further submitted that even notice is issued by the.
My lord, by the fourth respondent, my lord, that is the Tahsildar.
By the Tehsildar for removal of the said construction.
No, to directing the Panchayat Development Officer to take over possession of this,
To take over possession of the said construction.
yes.
Full stop. In view of the above developments and in view that the representation of the petition is pending, without going into the merits of the case, the petitioner is at liberty to pursue his representation. The authorities shall verify the textual aspects of the subject matter and act in accordance with law.
My lord, there is a report, already it is, the construction is made. So to recover,
Accept the above limited observations, so the present petition is not entertained and stands.
time limit may fix, ma'am, within time bound, in a time bound
There
manner.
is nothing, there is some shade is, they will remove it.
The Passover matters, still number 6. H. Maltesh, still number 6.
None was present in the first half as well as in the second session when the contempt petition was called out in the full stop in the larger interest of justice. Stand out to 16th January.
Still number 11. Mr. Nataraj Sharma.
Petitioner in this, my lord. But in this case, last occasion, my lord, I submitted that the prayer number C is not pressing and the interim order also. Coming to this prayer number, interim prayer, my lord, annexure F has been withdrawn by the respondent, my lord. So, my lord, now for pending consideration is only annexure E, that is the notification dated 31st/8/2023.
That has been withdrawn.
No. 11/11/2024 is been withdrawn. And
31/8/2023 notification, which is featuring in prayer number A, my lords, has been withdrawn on 18/12/2024.
If that is, my lord, I will withdraw the case with the liberty to file a fresh petition if in case for any fresh cause of corruption.
That may not arise also, my lords, because my lords had mentioned the judgment in the morning.
Shall we record your statement?
Yes, yes.
What is this?
My lords, this is the judgment my lords had passed with regard to a PIL for the service matters. As to how it's not maintainable.
My lord,
My lords had mentioned this, so I thought we should just place it on.
one submission in this, my lord. I am not challenging any appointment, my lord. I am challenging the notification, which is the conditions.
But this doesn't survive because of the withdrawal of.
Yes, my lord. Yes.
Learned advocate, Mr.
Mahesh
Chaudhary, who appears on behalf of the respondent number 5, Gujarat, 5 Karnataka State Pollution Control Board. Upon service of the copy of the petition in advance, appears to state that prayer in paragraph 31 small a to set aside what is the 31/8/20 circular?
No, my lords, it was the guidelines. my lords,
Guideline dated 31/8/23
for appointment of chairman, member secretary and members.
dealing with the subject of appointment of the chairman oblique member of the.
Members and member secretary of the pollution control board.
Member oblique member secretary of the pollution control, state pollution control board has been withdrawn on 18/12/20.
Yes, my lords.
The principal prayer does not survive. Consequently, petition itself will not survive. As stated by learned advocate, so and so, so and so.
Liberty may be required. If there is any fresh
Yeah,
corruption.
that's
Any of the
liberty.
statement made on behalf of the State Pollution Control Board dismissed as not survive, petition is dismissed as not surviving.
Liberty, my lord. If in case the same guidelines is continued, my notification is continued, my lord.
How can
My lord,
it
I'm
continue once we
challenging,
withdraw it?
I'm not challenging the conditions, my lord. I'm not challenging the appointment, my lord. I'm challenging here only the flags and conditions, which is against the honorable court's direction.
You want
In,
liberty?
in 2021, my lord.
You want liberty?
If there is any same country, the
You want
same-
liberty? You want liberty?
Yes, but
Given,
if
given,
the same-
liberty is given.
much obliged.
Grateful.
Obligement.
You are received or not?
Yes, my lord. Grateful, ma'am.
Any further development, she will give fresh cause of action. Any subsequent development in the subject matter will give fresh cause of action to the petition, correct?
Yes, ma'am.
Earlier liberty is better or this liberty?
This liberty is good. Thank you.
December 36, S.Y. Shivali.
This is a case for not writ of mandamus. An application was filed in the year 2015 for seeking quarrying lease, but in respect of ordinary building stone has been kept pending till the year 2025. Not they have not taken decision. There are already both NOCs, not the joint inspection report as well as technical report is issued. But however,
Consider the application dated 15.
please, 2015 application.
So what you are doing till?
Annexure B, the application filed for seeking quarrying lease.
My lord, the application will be considered once we receive the revenue NOC, my lord, from the deputy commissioner. My lord may dispose of the writ petition, giving us some time, my lord, to dispose and to consider and dispose of the
It
uh,
application.
is pending since 2015.
My lord, they were subsequently
In
there
fact,
were
it was
developments.
rejected
my
in the
lord.
earlier occasion. In the earlier round, it was rejected in the year 2016, which I questioned it before this honorable court in WP number.
Where is page?
Annexure C is the order,
Page.
page 36 not.
Annexure B is page 36.
Annexure C is the order passed by this honorable court.
Not order, your application of. 50.
Application annexure B not.
B, where is?
Annexure
page?
B.
Page.
Page 26 not.
20. 23.
Dated 25th April 2015.
23 is this.
My lord, the
70.
rules had been amended subsequently, because of which the application couldn't be considered. In fact, it was rejected on 18/11/2016, my lord, because Rule 8B had been
I questioned it
substituted.
in WP number.
Yes.
For this honorable court in WP number 55855 by 2018, which endorsement came to be set aside and sent it back to the respondent authorities to execute quarrying lease. After that, they have issued NOCs and joint inspection report as well as technical report. The technical report is issued in the year 2019 itself. That is annexure F, page number 56 not. After that, they kept it pending till the year 2024. In the meantime, Lord, on 23 Lord, 3/2017, Lord, rules came to be amended, Lord, under which the applications came to be, Lord, became eligible. Now, Lord, they have sent this letter to the deputy commissioner dated 23/2/2024 to the deputy commissioner to get opinion and NOC from the deputy commissioner, which is not permissible according to me. Not because already NOC is there on record at page number 47, annexure D.
Our learned advocate Mr. So-and-so petitioner and learned additional government advocate Srimati Neelopal Akbar, who appears upon service of court petition in advance.
My lord, notice had been issued on 5th of November, my lord.
Notice is issued upon issuance of notice by this court. Yes, notice. Petitioner has made application for grant of co-release for extracting the ordinary building stone in part of survey number, in land part of survey number 52, at measuring 6 acres, situated at Anaguddi village, Samdurga Taluka, Velga village. It is the case of the petitioner that the petitioner has complied with the requirements and conditions and the formalities prescribed under the Karnataka Minor Mineral Concession Rules 1994. It is the grievance that the application is still not processed, which was filed as back as in the year 2015. The application, the said application figures on the copy of the said application figures on record of the petition. It is also the case that the application, it is the case that the application has not been processed after the amendment made in the minor mineral concession rules, whereby Rule 8 capital B was substituted in the year, substituted by notification dated 17/3/23. according to the petitioner, he is eligible for grant of foreign lease. However, his application is not attended to. It is stated that authority is given no objection and positive opinion in favor of the petitioner. On the basis of the above premise of facts, prayer is made to direct the respondent authorities to consider the UL application dated 25 for release application dated 25/15 of the petitioner for grant of the release. Paragraph. Having considered the facts of the case and having further considered the submissions made by both the sides, it will be appropriate if the respondent is directed to consider and decide the application of the petitioner, which is since long pending, by verifying the merits of the application and decide in accordance with law, which shall be done preferably within a period of 8 weeks.
Obliged.
The petition is disposed of in the above terms. This court has not gone into the merits of it.
Number 37.
My lord, this writ petition doesn't survive for consideration, my lord.
No, indeed not, my lords. On 1/6/2023, coordinate bench was pleased to pass a detailed order that the government has to file a reply because this pertains to pre-university colleges running in violation of the government's own regulations. The state government itself had identified 632 colleges which has been running in violation of the rules. So
Any stay was operating in the.
There was a stay, my lords. As against respondent number 5, there was a stay.
What of the stay? Against construction.
Against respondent number 5.
Against construction.
Please, my lord.
Construction.
Respondent number 5.
I am appealing for respondent number 5, my lords. My lords, we were running the college, my lords. They had challenged it not to give registration and permission to run the college, my lord. Subsequent events have taken place, my lords, where I've shifted the college to other location, my lords. And the government has also given the permission, my lords. I've shifted the college, my lords.
My lord, I'm filing an affidavit to that extent.
Shifted the college.
No, with regard to the other colleges, my lordship may kindly take the order dated 1/6/2023.
Other colleges were not concerned.
No, the government itself has identified.
Concerned only with the college is shifted.
No, indeed not.
In fact, 23rd March, your lordship may kindly see, 23rd March 23, this court has observed we can't give a blanket prayer. Paragraph 4, your lordship.
No, my lord, may kindly note your 1/6/2023 order.
1/6/20.
2023.
23rd March 23 is very clear order, your lordship.
Paragraph 3 of this order, 1/6/2023. If I may be permitted to read, my lords.
There is no such order.
1/6/2023.
My lord, prayer pertains only to respondent number 5, my lord. If my lord were to see the prayers in the writ petition.
It has been amended. There's an amended petition filed. Paragraph 3, perusal of the record further shows that a memo has been filed on behalf of the state government to the learned government advocate on 8/7/2013, indicating that the state government itself has found 632 institutions for not having the required area of land, and a communication in this regard was forwarded to all 632 institutions. In view of these facts, we call upon the state government to file a detailed statement of objection, reply affidavit, and response indicating the events subsequent to the memo dated 8/7/2013, such as response, if any, to the communications forwarded by the state government department to the 633 institutions, and on receipt of response, that was, what was the further actions initiated by the state government. Also to specify whether the rules of 2017 make provisions for submission of report to the state government by the institutions concerned, whether the said institutions complies with all the requirements which are prerequisites, whether the rules provide for inspection by the authority on receipt of the report by the concerned institution, and whether there are provisions in the rules for further periodic inspection. and whether there are further provisions about the action to be initiated against the institutions for their failure to comply with the provisions. In view of the aforesaid response not being filed, the same may be filed within 3 weeks and a copy of the same be supplied to the petitioners. With regard to respondent number 5, the council submits that subsequent to filing of the petition, it has requested for change of place and permission was granted. So the learned government advocate shall go through the said memo and file a response to the submission in the memo as well. So, there's already a lot of process. Notices were issued by the state government itself. So the state government has to comply with this order of the coordinate bench dated 1/6/2023, If the filing and affidavit have not been served, that affidavit may be.
Complaint ಮಾಡಿದ್ದೀರ. But ಅಷ್ಟೇ, nothing surveys. It is only against this institution. It has been.
Now it is shifted to Aswini Colony, Vidyanagar.
Yes.
Please, my lords.
With regard to respondent number 5, I have addressed. But with regard to the other 632 institutions, they have not yet submitted their response as per the.
The college is shifted, Mr. Council.
The other colleges, my lords may kindly note, the government itself has.
File one petition for only one college.
No, indeed not, my lords. It's been amended and there's a government itself has identified 632 institutions. My lords may kindly peruse the memo filed by the government, 8/7/2013.
Sorry, after this is of 2009. 2009.
That was because there was a challenge to the regulations. That was deferred. The hearing was deferred. An amendment has been taken place. But with regard to 632 institutions, my lords, it may still survive. I would request time to peruse this and we will make our submissions. Because with regard to 632 institutions.
Cause of action arose because of my lord respondent number 5. My lord, we have submitted that, my lord, we have initiated action and now they have shifted. Now the rules of 2012 have been amended, my lord. That I have called out at paragraph 7 and 8. What survives for consideration without there being a cause of action, I don't know.
The government itself has filed a memo, my lords. If my lords may kindly peruse the memo dated 8/7.
Your lord.
On your phone, instructions came to withdraw the petition.
Indeed not, my lords.
Looking at your phone. You're looking at your phone while arguing.
Indeed not, my lords.
He's not.
And tell us if instructions have come to withdraw the petition.
My lords, I may be granted a short accommodations. Let me verify.
In 2009, no.
No, my lords, because of the order dated 1/6/2000, my lords may kindly peruse the memo dated 8/7. After this, my lords, I will not. The government advocate has filed the memo dated 8/7/2013. That may kindly be seen.
Your lordship may kindly see the 23rd March 2023 order is very specific, your lordship. 23rd March 2023. Yeah, it is Narayana only against 5th respondent.
We'll only say that it is shifted to different place.
No, my lords, may I kindly see the memo, my lords. One, because the government itself has identified, my lords, look at the action. They have only identified that these institutions are running in violation and they should notices to these institutions.
Different.
This prayer has been amended, my lords. It has been included. 8/7/2013 memo, if my lords may kindly peruse, my lord.
Well, those institutions are not parties here.
They have issued notices and there was a direction to.
Issue notice, they should be arrayed as parties.
My lords, kindly peruse the memo, my lords. The government itself has.
How many petitioners are there? So many? Or so
We have
many?
amended the petition. My lords may kindly take the amended.
Kindly see 23rd March order, that is recorded, 23rd March 2023. Details have been recorded, detailed order has been passed to you.
23rd March 2023.
Our amended prayer is to restrain the pre-university department from granting extensions for colleges which do not adhere to the rules, and to withdraw these extensions. And the government itself has identified that 632 institutions do not have the required area to have universities, institutions, and notices were issued. So let them place on record what action has been taken, because there's already a direction, and the government itself has identified these errant institutions. If the government identifies that these institutions do not follow the rules, kindly, and notices were issued, let them at least place on record that if they have complied, we have no objection, my lord. Let them at least place on record what action has been taken. 8/7/2013, there's a memo that the government has filed.
Styled as public interest petition.
My lords, I kindly request for an accommodation. I would take instructions and
Your accommodation is only in our order. There is no other record.
no, my lords, because the only reason, let me verify, because these institutions were identified, my lords, that they were not complying.
This is confined to the setting up of construction of a college or primary.
Indeed not, my lords. There's an amendment.
Number 5 only, and which
My
is
lord,
shifted.
no, there's an amendment to the petition, my lords. There's an amendment to the prayers.
Yeah.
The petition was amended in 2014.
And
2014.
For that amendment, your lordship,
Now, taking note of the issue, my lords, of widespread violation of the rules, the court permitted us to amend this, and the government has identified 632 institutions in violation. Initially, it was against respondent number 5, but it was been amended considering the public interest of ensuring that the colleges have minimum areas before running them in Bangalore.
your lordship, 23rd March 2023, the amendment prayer is also recorded by this court, and court has observed that you can't go on allegation against college and other things. That is not permissible. That is observation para 4 of this form report. Para 3 and 4 is specifically.
No, my lords, that memo.
23rd March 2020.
Order is passed.
No, my lords, the memo that we have filed may kindly be seen.
After the amendment.
Where is,
Yes.
No, that amendment.
is that order? You said some order is passed.
No, my lords, that order is after that order, 1/6/2023 order has been passed. Taking note of these aspects and the fact that
What paragraph?
let them place that on record, my lords, whether they are verified.
Read as respondents.
No, my lords, let them verify, because, my lords, this is a serious issue.
The particulars of the 632 and Mellon made them as respondents. Not having done that,
No, the government itself has identified these institutions. It is not at our request. The government, if my lords have the memo dated 8/7/2013.
As originally read for.
My lords, may kindly, because of these, I understand, my lords, that the difficulty, but then I request that because of these action already taken, let the government tell that, let them place on record, at least with respect to 632 institutions.
Now we are starting order. Interruptions will not be tolerated. You heard you enough.
My lords,
we are not inclined. You want to withdraw? We can give time up to tomorrow.
I'll By tomorrow, I will make my submission on withdrawal. if I
Look
feel.
at Mr. Ansu's 6 time till tomorrow to take instructions about the withdrawal of the petition. Send
Okay.
over to- Tomorrow is which date? 7. You
Please.
listed at 2000.
This is number 38.
My lord, matter pertains to the daily wage workers, the ad hoc workers at the Kalburgi and the Dharwad bench.
Yes, madam.
I'm sorry, my lord. My lord, in this, my lord, there is some, my lord, miscommunication between the DPAR, I apologize, my lord. My lord, the DPAR principal secretary and the principal secretary for law. My lord, may I have this day after tomorrow. I will get the information.
Yeah. If something positive can be done, then
My lord, I'm getting it.
that is the only idea. Yes.
This is number 39.
I appear for
I appear for respondent number 6.
is pertaining to that public road released in favor of the BDA. Frequently, there is obstruction that is being caused by the association of the Krishna Shantiniketan Welfare Association, please, madam, and the erstwhile land owners. So, your lordship, on the last occasion, that is on 6/12/2024, directed us to serve the copy of the notice to the BBMP, and BBMP is being represented by Mr. Sanjeev now, please, my lord. And after the intervention of the BBMP went there and removed the barricades, and they have removed the obstructions, please, my lord.
Nothing survives.
The main persons who have been frequently interfering are two persons whom I wanted to implead, please, my lord.
No, my lord, it was not even there. There was no barricades. As
No, that
Please,
has
they
been
visited the
removed.
spot, my lord, there were no barricades. There were no barricades at all.
I have produced the photographs with the dates.
Between the society and the public.
Nothing, my lord, they are using the roads and we are also using the road.
My lords, I appear for the association respondent number 6. My lords, as my lords, my learned friend has said there was no barricades. I have filed my objections, my lords, to IA2 of 24. My lords, where we have clearly stated that there were no barricades to begin with.
Your lordship may kindly peruse IA2 of 2024, ink page number 10, please, my lord, with date, with photograph of the newspaper. I have just affixed, please, my lord. This shows, your lordship may kindly see.
You filed some affidavit that there is no barricade or barricade.
Yes, my lord.
No,
Where is
they have removed it.
I have not filed.
removed it?
BBMP people, they have removed the barricades. Your lordship may kindly see, peruse the photographs.
So we'll say that BMC will take appropriate.
As on
steps.
date, there is no.
No, as on date, of course, as on this date,
Nine.
barricades are not there. It is removed. It is removed by them. And my grievance is very frequently,
As
these two private people, please, my lord, whom I wanted to implead.
After my lord direction, the assistant.
As on
director-
date, there is no barricade.
Now, as of now, there is no place, my lord.
As on
And
date.
they have dug a trench. They have dug a trench. It is there.
So if as on date there is no barricade,
Yeah,
as on
of
date
course.
we pass order.
Police, in spite of giving complaints to the police are not registering the case against these persons, please, my lord. That is also one grievance. A direction may kindly be given to the commissioner of police and the local station house officer to register the case against the persons who have been indulging frequently
So this is
these obstructions, please, my lord.
You argue only such matters where court is not able to pass the order. Here is a matter we can pass ready order. Nothing, there is nothing.
Though I have filed one application to implead two private persons, please, my lord. They are the persons who have been frequently putting obstructions, please, my lord.
In contention was there are barricades and obstructions.
Trench ಕೊಟ್ಟಿದ್ದೆ ಅಪ್ಪಳಿಗೆ. Trench ಹೊಡೆದಿದ್ದಾರೆ ಇವಾಗ.
When you are going to put barricade again?
My lords, I have filed objections to IA 2 of 24.
We are asking you when you are going to put your association,
Please, my lords, I appear for the association.
when you are going to put.
My lords, in our objections also, we have stated that barricades were never put, my lords.
No, never, when you will put now.
My lords, we will not put, my lords, barricades.
So we'll record that.
My lords, our submission, my lords, is that barricades were never placed. My lords, in order to restrict
No, we
movement.
understand that they were never placed. But we want you to know when you will place it in the future.
My lords, in fact, my lords, what has happened is, my lords, the boundary wall of the apartment complex, my lords, is adjoining, my lords, the supposed public road. My lords, what has to happen is, my lords, there has to be a determination also, my lords, by this honorable court that that road is a public road. Because, my lords, the development plan, my lords, according to us, does not show that it is a public road. My lords, that has to be finally determined in this writ petition, my lords. That is for at the time of final determination. My lords, as of now, my lords, barricades were never placed in order to restrict movement, my lords. And that, my lords, I placed in my objections to IA 2 of 24 filed today, my lords. My lords, ultimately, whether it is a public road, my lords, or it is, my lords, a road belonging, my lords, to the apartment complex is, my lords, subject to final determination in this case. Please, my
They have released the road in favor of BDA. Now they say that whether this is to be determined.
That aspect of road to be determined, it has to be the civil court.
No, I have produced the
Court has to do that.
copies of the release deeds, please, my lord.
We have removed the very. Mr. BDA.
No, we earlier, my lord.
Removed.
I appear for, we did not remove, my lord. It was not there at all. In fact, the director went there. My lord, the assistant,
BDA.
after my lord's, my lord, after my lord's
This
direction.
road is
my
a
lord,
public road.
It's a road. It's public. It's BDA
a
is
public
maintaining
road.
that road. BDA is maintaining the road.
It's a public road.
It's a public road.
It is a public road, my lord.
Time and
It is a public road.
Yes, it is a public road.
Now we are asking your colleague. It is a public road.
My lords, my instructions are, my lords, that the development plan, my lords, does not show that it is.
Public road.
Please, my lord.
It is not a public road.
My lords, my instructions are, my lords, that the development plan, my lords, shows that it is not a public road.
So if it is not a public road, we are asking you when you are going to put up barricades.
My lords, we will not be
Sir,
putting up.
you file an affidavit that this is a public.
Me, my lord.
Asked, natural.
Yes.
Your what you were stating in open court, you file an affidavit.
No, my lord, the road belongs to BDA, not to BBM.
So you filed that affidavit.
Yes, my lord. It was
Fine.
not handed over to BBM.
Learned advocate pursuant to will record this.
First testament.
It belongs to BDM.
You are BDA.
Yeah, I'm for the bidding.
You are BBMP.
BBMP. The road belongs to BDM.
BDA.
Yes,
It was relinquished to the BDM, my lord. It is in the.
So you know, don't know. The road belongs to you.
Belongs to, it's a public road, my lord, because it is the.
So file your affidavit.
Yes, my lord. Yes.
It is the stand of the Bangalore Development Authority.
the developer himself has filed an affidavit, please, my
Bangalore
lord.
Mahanagarapalika, the respondents hearing that the road in question where the barricades were alleged to have been put up by the apartment owners is a public road used by the public.
And it is relinquished to the BDM.
The affidavit will be filed stating the above fact by the said respondents before the next date put up on 20th January.
No.
My lords,
On
IA
my
2
IA
of
for impleading, please, my lord. Notices may kindly be issued to the proposed respondents, please, my
he
lord.
is widening the scope of the writ petition.
Which proposed respondent?
Two persons, they have been frequently digging the trenches, please, my lord, just across the road.
The civil court.
My lord, that's cause of action.
Public road, they have been digging the trenches frequently, very frequently.
We'll see on that day once they file it.
Oblige, please.
My lords, IA 2 of 24 may be disposed of, my lords, now that counsel for BBMP, my lords, has stated that there were no barricades.
On that day we'll dispose of all together.
Please, my lords.
To be listed at 2:30.
Yes.
Looking to the age of the petition.
Oblige.
Date?
20 Jan.
Number 40, to GS Venkata Subbaraw.
12/3/2024 and subsequently, my lord, renewed prior to 18/12. To, my lord, submit a report in a sealed cover, my lord, is direct. That report was time bound, my lord, to be submitted in 2 weeks.
This, my lord, it is in Kannada. My lord, if
Honored additional government advocate, Ms. Neelo Horakpur, 6 time to file on record the report which was prepared pursuant to the last order of the court.
my lord, but my lord had directed that this report should be in a sealed
Sealed
cover and it
it's
should
all open.
be placed before
Produce
my
the
lord.
report as per the directions issued by this court.
Obliged, ma'am.
Please send over to 22nd January. Or little later, 28 Jan.
Obliged, ma'am.
Interim order to continue. Interim, what is the interim order? Next, yes, my lord, is the recommendation stay. Order shall continue to operate till the next day. Grateful.
Number 41,
Lord, I'm representing petitioner, my Lord.
petition.
Lord, this is a public interest litigation
Hmm.
filed by a resident welfare organization
Hmm.
and few residents residing in vicinity to the public park, which is illegally occupied by few squatters who have been rearing pigs in the public park, my Lord. Lordship, may kindly see annexure A, page number 51, my Lord. Translation is at page number 51. Serial number 22, 23, and 24, my Lord. Lord, from the year 2008, my Lord, representations have been given to several, all the concerned authorities, my Lord. Your Lordship, may kindly see page number 51 for a moment, my Lord. 51. At serial number 22, 23, and 24, my Lord. Some 10.5 acres of land has been converted from agriculture to residential purpose, my Lord. And subsequently, your Lordship may will get at annexure B, page number 55, my Lord. This is a layout approval sanction, my Lord, layout plan sanction. And your Lordship may kindly see annexure C, page number 57, my Lord.
File some report or
Lords, I represent Lords the municipal authority, city municipal corporation, Lords Tumku. Lords, in this matter, my Lords, the deputy commissioner, my Lords, has allotted 4 acres, 14 guntas of land, my Lords, for shifting these persons, my Lords, who are occupying the area to another place. And my Lords, certain my Lords, funds have been released to the extent of 24 my Lords, lakhs. And thereafter, my Lords, the authorities, the social welfare department of the government, Lords, the municipal authority, and as well as my Lords, the planning authority. Lords, everybody, my Lords, are taking steps, my Lords, to shift them to a particular place. My Lords, where, my Lords, the certain amenities and facilities, my Lords, are being provided. It will take some time, my Lords. I'll be able to place on record, my Lords, all these details. My Lords, after 2 weeks, my Lords, I'll get the copies, my Lords, of the steps taken. And thereafter, my Lords, I'll place it on record.
From 15 years, my Lord, they have been giving the representations, my Lord. Lordship, may kindly see my index, my Lord, the index which I have filed at index, my Lord. Lordship, may kindly see. From 2008, my Lord, annexure E, 2008 first representation, my Lord. 2012 representation to City Municipal Corporation. 2012 representation to Land Conservation Force. And my Lord, annexure E4, 2012 representation. 2014 representation at annexure E6, my Lord. 2015 representation to same City Municipal Corporation in 2015, my Lord. And 2016, we have written letter to Chief Minister, my Lord, annexure E10, my Lord, page number 84. In 2016, we have written letter to Chief Minister. In 2018, my lord, we have again written letter to Chief Minister. And my lord, from 2022, 23, continuous representations have been there, my lord. From last 15 years, my lord, your lordship may kindly see, this is the last hope to the residents of this locality, my lord. This honorable court is the last hope, my lord. From last 15 years, my lord, they have been, in fact, several ladies, my lord, who have, when the officers of the respondent authorities had come there, my lord, they have even went and who held their feet, my lord. They kindly vacate this and they have approached they have been begging the authorities, my lord. And very filthy smell is coming from this.
Hope is never last. If it is last, it is not a hope. So let them file affidavit. The prayer in the prayer in this public interest petition is to direct the respondent authorities to evict the illegal squatters in the public park located in survey number 339/2, 40/1, 40/2 and 40/3 at Upparhalli village, Tumkur district. While learned advocate Pereira, Mr. So and so for the petitioner has submitted that several representations have been made, yet they have remained unattended by the authorities. From a learned advocate, Mr.
Subramania.
So and so for respond number.
Lord's respond number, it's 4.
4.
3.
Submitted.
I'm
that
sorry, Lords,
they
3.
will file affidavit detailing the proposed steps
Please.
to be taken to evict the squatters from the park.
Lord, 2 weeks time may be given, my lord. Let this writ petition be kept pending, my lord.
At this stage, learned advocate for the petition agrees that 2 weeks time may be given. Accordingly, stand over to 22nd January.
Let's move.
Obligement.
Don't write it, don't write.
Number 42, complaints in contempt matter.
Serial number 42, I appear for the accused number 3, your lordships. I had filed a complaints affidavit on 12/12/24. It is for the complainant to report back on the scene. And if it is complete, the matter may be disposed of, your lordships.
Which for the complainant?
Mr. Adinaranappa.
So you decided the representation.
Please, your lordships,
Endorsement dated 25/3/24.
please.
The only direction of learned single judge in order dated 11th September 23, which is made subject matter of the present contempt proceedings, was to consider the representation of the petitioner within stipulated time. Full stop. In response to the notice, my affidavit of compliance is filed. Full stop. Learned advocate, so and so, stated by inviting attention of the court to paragraph 5 of the affidavit that the representation is decided by response 3 and endorsement dated 25/3/24 is issued. Full stop. In view of the above, the direction, submitted learned advocate to the respondent, has been complied with. Paragraph. Since learned advocate to the complainant is not present, in order to since learned advocate the petition is not present, stand over to tomorrow. Inform him on 7th to be listed at 2:30.
Much.
43, stays Ramurthy.
For the complainant, my lord. The lordship may kindly see the order dated 2/9/24. 6 weeks time had been granted for complaint because they submitted that a review application has been filed. And Review application.
Review
has-
petition 6 weeks. What did you do?
Learned judges sitting in a division bench, my lord. We are awaiting the listing of the matter. Learned Judge, my lord, is sitting in division bench, my lord. We are awaiting the listing of the matter. We have.
So you want the court to change the roster?
Sorry, no, my lord. It's a review petition, my lord. It has to come before the same learned judge.
So we don't know all these things. We want.
Lordship may
all
kindly accommodate us. We'll move the.
We'll
request.
grant time. Stand over to 3rd March.
Oblige, my lord.
Before which date the appropriate orders will be obtained. in
Please,
the-
please, my lords, please.
Pursue the registrar judicial.
We'll do it, my lords. We'll do it. Oblige.
This is number 44.
Lords,
Shrikant Reddy.
Hearing for accused number 3 and 4, my lord.
Lords, in this matter, my lords, writ appeal was filed. It was posted before this honorable court. Notice has been issued on delay, my lords, and the matter is posted in February.
Lordship,
My lords,
this matter also connected with, along with that writ
Lordship may
appeal,
kindly
Lordship.
connect this matter.
Appeal is
Writ appeal.
Writ appeal number.
1763 of 2020.
So stated that writ appeal number 1763
63 of
24,
2024. 20th to 2024 is the case.
in which the order brought under the contempt jurisdiction is challenged, is going to be posted on
20th to 2024.
22 to
25.
22 to 25.
20 to 2020.
20th February 25.
Yes.
In that view, the present contempt proceedings shall be listed along with the said appeal on 20th February.
Please.
Your Lordship, in this matter, government has filed a writ appeal, but accused number 2 and 3, Your Lordship, they are filed
Lords,
complaints.
we'll file the reply. And also, my lords, we
Not
have
given
also
any reply.
given the proposal for the payment of pension and other entitlements to the government.
My
uh,
lords,
Through
this order, my lords, is passed on a joint memo filed by the private respondent and the complainant, where it is a grant-in-aid institution. Government is not made a party in that joint memo, my lords. We cannot be bound by the joint memo. Therefore, we have filed a writ appeal, my lords. It may be heard.
Number 45. Abdul Nazir Matar.
File wakalat for accused number 4, 5, and 6.
Yes, in this matter, the contempt itself will not survive. Your lordship may kindly see the order. The writ petition has been dismissed.
Page allowed or dismissed?
Ink page 38, Lordships.
Page 38.
Ink page 38, Lordships. There was an undertaking given by the HCGP for your Lordships itself. It is the order of your Lordships. It was dismissed because it was in a representative capacity. But HCGP has given an undertaking that they will give opportunities for all the residents who are there. Because we are not a party to the particular proceedings of the Tahsildar. In page 30, Lordships.
So what is the contempt?
Contempt is they have interfered with our property without giving any notice to us. They have demolished, I've given the photographs, everything. Lordships.
We have
They have
not.
threatened, they have threatened the people there. Many more residents are filing contempt before this honorable court. Some
There
people
are
have lost their
private
houses.
Respondents, my lords, there are private respondents. So far as the state is concerned, we have not done anything because there are multiple orders, status quo orders. So we have not taken any action, my lords. So here the order is
Lordship.
dismissed and if at all there is any demolition, it is not by us, my lords.
No, the council is probably pointing out the earlier part of the paragraph 3. If
Three
anybody-
election.
If anybody has to be
Yes.
evicted,
3 Lordship, yes.
That line.
Yes, Lordship.
please. So we are no way concerned because there are multiple orders passed by this honorable court, my lords. In fact, the writ appeal also is pending here.
So you are not evicted the complainant?
We have not done any demolition, my lords.
Lordship, my humble submission, I'll be very clear about it. The photographs, if Lordship may kindly see, this is how they're doing it. They come before the court with unclean hands,
Lordship.
demolish, threatened today, within 3 days, their house is not there.
Lords, it is at the hands of private respondents because
I
there
have
is a
seen these kind
dispute.
of, I have seen these kind of news only in UP, not in Bangalore.
Not appear for accused number 4, 5, and 6. Subsequent to your lordship's order, my lord, there were subsequent writ petitions where, my lord, the writ petition was allowed directing the Tahsildar to implement its order. And, my lord, now there are multiple writ petitions and writ appeals also, wherein, my lord, this court has directed only status quo in respect of appellants who are before your lordships. In other cases, my lord, the order of the learned single judge is in force.
You file replies.
Please, my lord,
File
I
reply.
want to file reply.
I am not a party to those writ appeals and writ petitions.
Right.
I am an aggrieved party before the Lordship.
Lordship may grant me
I am
3
only being
weeks time
protected by this court, this particular order.
Let them file. In fact, there is nothing, but still.
Please.
No, there is a lot of things, Lordships. A lot of people are coming forward to file this contempt only based on this. This is the only help they have. The
20
order is the only help.
20th February.
Please.
Obliged.
In which time the reply, if any, shall be filed by the respondents.
Number 46. Adi Narayanappa.
Here we have complied with the order and appointment order has been issued, my lord. So I filed a memo to that effect.
Learned government, additional government advocate. Promote the occasion. Invite citizen of the court to the memo dated 21/9. Filed by her, stating that the order under contempt is complied with by giving appointment as panchayat, giving appointment to the complainant as panchayat development officer. Wherever the memo reads as under, and quote the memo. In view of the above, nothing survives in the
Please.
contempt petition with this course of record. If any, in case of genuine difficulty, liberty to revise is reserved.
Number 47. Mr. Ravi Shankar.
Here again, we have complied. my
Pardon?
lords, with- We have
Again,
filed.
for the complainant, my lord, they have given some representation 3 months before. They will comply the order, but
Complied with.
no, they have not complied.
Yes.
Lords, their representation has been complied, my lords. Their case is that committee has to be constituted for the temple. My lords, the proposal has been sent for notifying the temple. Unless the temple is notified under section 23 of the act, the committee cannot be constituted. Therefore, we have issued an endorsement to state that once it is notified, committee will be constituted. And we have stated so in the affidavit, my lords, your lordship may kindly.
Heard learned advocate Miss so and so for the complainant and learned additional government advocate. Srimati Pramodini Kishan for the respondent. Before learn a single judge. The case of the petitioner complainant was that his representation dated 25/4/22 was required to be considered for the purpose of constituting the committee for the management of the temple concerned, notified under section 25(3) of the Hindu Religious Institutions and Charitable Endowments Act 1997. It was the case of the petitioner that there is a need for formation of such committee. The petition was disposed of by learned single judge as per order dated 4th July 23, whereby the respondents were directed to look into the grievance of the petitioner, time bound, and consider the representation. When contempt of the aforesaid directions was alleged by the complainant by filing this petition, in response thereto, the compliance affidavit was filed by the Assistant Commissioner of Uzarai MUZDRI Works Corporation Area, Podium Corporation Area, Bengaluru, in which it is inter-alia stated that respondent number 2 authority has considered the representation of petition, representation of the complainant, and endorsement is issued on 23/9/24. It is stated that as per the endorsement, it is provided that the necessary action has been taken to notify the temple under section 23 of the Karnataka Hindu Religious Institutions and Charitable Endowment Act 1997. Pursuant to complaints made by the public, it is stated that once the temple is notified under the said provision, the managing committee shall be constituted as per section 25 of the Act. In that view, in the above view, the authorities have substantially acted in compliance with the directions of learned single judge. The committee could be formed only after the notification of the temple under the Act. In the above light, it could not be said that any of the respondents have committed contempt of the court, much less a willful contempt. The then proceeding does not survive any further. The petition is accordingly disposed of as not surviving.
Number 48. Ranganath Joy.
Actually, termination and equal pay for equal work filed before the learned single judge has been dismissed on the ground that there were no posts at the stage of admission, whereas under the Right of Information Act, I have obtained the information that there are vacant posts, my lord. Page number 50, there is a clear, I was working as a OT technician. There are 16 sanctioned posts, out of which only 6 were filled. 10 were still vacant, but the learned single judge at the stage of admission itself, in para 5 at page 15 says that the endorsement would indicate there are only so far a sanctioned post of OT in the second, in 6 posts. 6 working persons, 10 posts are there. That Right of Information Act I have produced, page number 52. The very authority chief Right of Information gives that the total paid.
It was outsourced.
No, it's not outside. They are recruiting the Kidwai. In fact, similar matter who have put in 10 years, they have been regularized by learned.
But then you can't force the employer to appoint.
No, it's not question. When a person similarly situated were continued, only I was discriminated. I earlier approached this honorable court, and just because I asked for equal pay for equal work.
Was the prayer in the petition? Main prayer. Grounds. Then the prayer. All for the records. Non-continuous. You are in service?
Yes, please.
You are in service, not.
No, no, I mean, not, I notice my bad.
What is the post?
Yes, please.
Technician. So you can invoke the industrial.
No, my lord, they are employees, they are Article 12 institutions, government bodies. Hidwa Institute is a state government institution. Similar matter already allowed by this learned single judge, but they have put in 10 years of service. That's the only difference. I will point out, my lord, regarding the availability of post.
Delay is there.
Delay is there. There's a delay, man.
No, I filed a review, my lord, before the learned single judge to point out that.
Delay of 25 days.
Yes, that I have filed a review, and after dismissal of review, I challenge both the orders presently.
No, no.
Review was disposed of very recently, my lord.
Delay in filing this appeal. Delay in filing, there is a delay of.
Yes,
25.
delay, if it is construed from the date of review orders, there is no delay.
We don't, office says there is a delay. Who appears?
Respondent number 2 has to be notified. ma'am.
You are appearing for both the.
Respondent number 1, I will appear. ma'am. 2 is they have a special
two.
panel counsel.
2 is served or not?
I will take a service on the point too.
Director, Hidwa Cancer Institute. It's a separate. Notice has not gone.
My lord, respondent number 2, my lord, they have a panel.
They have a
counsel.
separate counsel.
Separate
I will
counsel.
serve
and
the
panel.
copy on the said.
Served number 2. Notice.
Counsel who appeared before, one Arvind Chavan appeared before single judge, I will serve. Arvind V. Chavan appeared.
Number 2. Returnable on. February.
The date may be given.
21st February. Because of that. Full bench has been. Oh, bye.
Number 49, the state appeal.
Respondent number 2 in this case, ma'am.
Here also 192 days deal.
The delay may be condoned, but I have to appear for the first respondent.
All the respondents are appearing.
Yes. Even the second respondent not has filed.
I undertake to file a wakalat, ma'am.
Parties, this application is filed paragraph for seeking condonation of delay. Not served. Then
Not, she has appeared now.
I received the wakalat today itself, my lord. I'll file it in counter, my lord. I'll undertake to file the wakalat, my lord. I'm appearing for the respondent number 2, Rajiv Gandhi Housing Corporation Limited.
that's right. We can condone the delay or. Third learn and additional government advocate. Mr. Harish for the applicant state from a learned advocate. For respondent 1 and learned advocate Miss so and so for respondent 2. You are number 1. Harish is 1 and 1. You are appearing for whom?
State government has filed the
Yeah, it's
appeal.
the government appeal, my lord.
Government appeal.
Correct, but
My learned friend is appearing for respondent number 2 now.
the appellant state and its authorities. Learned advocate Miss so and so from respondent 1 and learned advocate Miss so and so 2. You are for Rajiv Gandhi 2, who shall be filing his wakalam now in course of the day. Course of the day.
Tomorrow I'll file it, my lord. Today only I received.
Within 2 days. Full stop. This application is filed. Trying to condone the delay of 192 days, which has taken place in filing the appeal. Full stop. It is stated that after the judgment and order was delivered by learned single judge, time was consumed in seeking civil opinion. Full stop. It was stated that thereafter the files traveled to the hierarchy of authorities in the process of decision making. The time was consumed in such process. Paragraph, the applicant is a state, an impersonate body, therefore consumption of time in decision-making process is inherent. Most of the reasons indicated are administrative in nature. Negligence, element of negligence or culpability could not be attributed. The above view, the sufficient cause is made out to condone the delay of 192 days. It is condoned. Application bill shall be listed on 10th February.
Number 50, the Santosh Nagaraj.
My lords, appearing for the petitioner, my lords.
My lords, I appear for the
Time, my
respondent.
lords, for compliance of office objection, my lords.
At the request of learned advocate with the appellant, stand over to 11th February.
Please, my lords.
Number 51, Mr. N. Shankar Narayan Bhatt.
Second respondent, my lord. I filed this application for modification. Heard the copies of the IA, my lord. Office objections are complied. Office objections are complied, my lord. Assert the copy of the IA. That this is a disposed of matter, my lord. In a PL, the second respondent was directed to hand over 16,000 square feet of land to the BDA towards civic amenity site. This direction, my lord, was issued because in a suit filed by R5, the second respondent had conceded to give up 16,000 square feet. This, my lord, we are agreeable. But on verification, we find, my lord, that the fifth respondent is in possession of only 8,182 square feet, not 16,000. Therefore, my lord, for the third direction, we have sought modification, my lord. Lords may see page 18, my lord, the third direction which my lords have granted, my lord, in the PI. The matter is remanded back to the first respondent BDA to hear the petitioner and the society before considering the application of the society for modification of the layout plan and pass appropriate order in accordance with law within a period of 6 months from the date of receipt of this copy. The BDA shall ensure a clear civic amenity site of 16,000 square feet is made available to the society. This, my lord, though we had in a suit agreed for 16,000, what we have handed over is only 8,182 square feet. I have produced this sketch also, my lord, where the BDA also agrees that it's only 8,182 square feet. If an independent association, my lords, may appoint a commissioner at our cost, my lord, that work also be done. That 8,000 remains. What we'll hand over is, my lord, an independent area of 8,182 square. This reasoning of 16,000, my lord, should find at para 13, my lord. Yes, my lord. The society, the resident association of the society, my lord, had raised the PIL on the ground that, my lord, that the society did not have the authority to relinquish 16,000 square feet of land in a suit. My lords upheld the contention of the petitioners and held that we are required to return back that 16,000 square feet. On physical verification, my lord, post the order, we come to know that though the agreement or the compromise was for 16,000 square feet, We had only given up 8,182 square feet. Para 13 of the judgment, my lord, please see.
So now what is the position?
8,182 square feet, my lord, we have handed over. We'll give an alternative site, my lord, whichever is available for that area.
Preparing for the BDM. My lord, I am for the BDM.
You are required to relinquish certain areas as civic communities, which you did not do. Initially, which you did not do. You alienated those sites in favor of third parties, that area. Then
What had happened was, there were 6 areas, this was demarked as CA sites, CA number 1 to 6. With CA number 1, my lord, there was a dispute. Civil suit was filed by the 5th respondent contending that he is owner of that CA site. There, the society entered into a compromise, where we agreed to give 16,000 square feet of land in respect of R5. We entered into a compromise on which a modified layout plan was released by the BDA, whereby CA sites were readjusted. The area of CA site did not go. That modified plan was challenged by the in a PI. There, my lords directed that we recover that 16,000 square feet which I had given for R5. That on verification we find, my lord, though the settlement was for 16,000 square feet, what R5 was in possession was only 8,182 square. Stick a restriction.
now see, once you form a layout, you are required to leave certain area towards CS side, which
will be
a
retained.
relinquishment deed has to be executed in favor of BDA. Now, the question is to BDA, have they relinquished the required area in favor of BDA or not?
Not at,
They are not accepting, my lord,
not at
since my lords have
My
directed
lord,
that we'll have to add that 16,000 square feet.
My lord, as per the zonal regulation,
Not allotted the entire area, required area.
Just saying, my lord, since my lords have directed it is 16,000 square feet, we'll have to give that additional 16,000 square.
no, even my lord, the approval, the condition of the approval of the layout plan as per the zonal regulation, they have to leave 15% of the area as a civic community site.
So what
There
is
is-
the 16,000?
That comes up
15%.
15%, that
And the 16,000?
No, my lord,
17,000,
large area.
17,102, it comes, 17,102. Now they want to give the only half of the area.
We are
Therefore, my
giving
lord,
the
they,
entire area, but my lords have taken the compromise petition on its face value that we are given 16,000 square feet to R5. We are given only 8. My lords may see para 13 of the judgment.
therefore, my
That will
submission, my submission is, my lord, let the joint survey be conducted. Whether the CS site as per the approved total extent is available or not. My lord. If their contention is they are only given 8,000, but our contention is given as 16,000 in the joint memo before the civil court, they have handed over to the private person. Therefore, my lord, the required 15% to be there in as a CS site in the approved layout plan. If the area left for the CS site, my lord, if it is 15,000, 17,000, then their contention is 8,000 is correct. Otherwise, my lord, it is 16,000.
Supposing there is only 8,000 square feet as contended by the society advocate, then
Yes,
does it satisfy the requirement of the area to be relinquished in favor of BDA? Or Should we penalize them?
No, my lord,
It
we
satisfies, my lord,
no.
because other site which we had formed as a site, the balance 8,000 square feet, my lord. We are giving in a layout site which has been formed.
No,
We are-
that site is also, they have verified, my lord, they conducted a survey. It was all constructed area. They are,
BBMP office is there, my lord. BWS's office is
No,
there,
no,
my
no.
lord. I'll just produce, that was considered by this court, my lord, and it was restricted to 16,000 square feet. We are ready for a joint survey, my lord. May I appoint a joint survey at my cost, we'll take care of it. Where the cost, whatever cost is, my lord. But the problem is, my lord, that we can't relinquish in view of this order.
You are for whom?
I'm for the second respondent, my lord, society.
Then you file affidavit. Huh? Both of you file affidavit.
I've already filed it along with the application, there's an affidavit.
Where is it?
The application is accompanied by an affidavit. Fresh affidavit.
File an affidavit stating the extent of the society, the layout that has been formed by you, number one. The extent of civic amenity sites that is required to be relinquished in favor of BDA, and the actual area that is available for relinquishment as of now.
I'll do that.
Both of you.
No, my lord, we have to file the affidavit after conducting the survey, my lord. Otherwise, we cannot, extent is cannot be available.
Because they don't know the actual area.
Actual,
Survey. Survey.
only if it is joint survey, my lord, it can be found out what is the extent of the CSIT available. File the affidavit.
Yes.
So both of you will file.
Yes, let them conduct a joint survey.
You conduct a survey and file.
Let the BDA itself conduct the survey, my lord, to the satisfaction. We are agreeing to that also.
Why not jointly?
What?
Why not jointly?
Jointly, my lord, we'll be present at the, when the survey is conducted.
Let the petition also present.
They will be present, but having heard, having considered the subject matter and having heard learned counsel. It is provided that BDA shall conduct a survey.
Joint survey. Joint survey.
Why survey?
Yes, because my lord,
We'll have to be-
tomorrow,
we'll have to demarcate, my lord,
if
to
we
the-
conducted a survey, they will dispute, my lord.
Along with respondent number one.
Two, my lord, R2.
In the direction it was there already. The matter is remanded back to the first respondent BDA to hear the petition and society before considering the application of the society for modification of layout plan and pass appropriate order in accordance with law within a period of 6 months. The direction.
Later part.
Yeah,
Later part.
I don't know.
And file a report along with the affidavit. The survey shall include the total area of the property and the area used. Area under use for common amenities. Right?
I request the office objections to be treated as compliant, my lord. I've served a copy on the.
Such reply shall be filed before the next date, extend over to 12th February, 12th February.
12th February. Very well, great. Obliged.
P2 is urgent, number 53. Mr. Vikas in 53.
Nobody is there. Typical 16th of January.
Number 54. The Shiv Prasad Shantanagoda.
For appear for the petitioner, my lords. That's matter pertaining to the illegal encroachment of the road area by respond number 9, the building which has been constructed by them. This honorable court had directed a joint survey to be conducted. Lord, on 31/7/2023, the ADLR has filed a report stating that there has been encroachment. If your lordship may kindly peruse the report on 31/7/2023, my lords. In the presence of all parties, even respond number 9. On an earlier occasion, even the Municipal Corporation of Davangere had filed a report stating that there has been encroachment of the highway area.
Appear for respondent number 7, my lord. That report was already filed.
And despite filing of the report and there being no injunction orders, they are not taking any subsequent steps under the Karnataka Municipal Corporation Act to demolish the said building.
Consider on 17th January,
Please,
not 17th, 21st January.
May I request for 2:30 minutes? May I request for 2:30?
Why? Once we find that it's liable to dispose of, we'll keep it. 21st.
Much okay.
Match up.
So number 55.
Lord, I appeal for the respondents.
Appear for the petitioner in this case, my lord. There's a PIL that's been filed regarding the rampant issue of false caste certificates, my lord. In fact, via memo dated 18th April 2024, they placed on record thousands of caste certificates that have been falsely issued, my lord, and in fact delivered a copy of all those details on the special counsel in this matter, my lord. Still, there are certificates being issued on a rampant basis for people who are not beneficiaries under serial number 38. So the matter is still happening. In fact, this honorable court had directed the state to file a status report, my lord, on the very first day of hearing. And also the second day of hearing, this court recognized the fact that the status report has not been filed, and had directed the special counsel to place on record all the inquiry that was conducted based on the hearing, and to provide a case status report. The same has till date not been done, my lord.
My Lord, my submission is, my Lord, steps have been taken to annul the caste certificate for whom they have issued a 2 caste certificate. Earlier, they have issued a Kabbaliga. Subsequently, they have issued as in a, my Lord, Talwara. I will place it before my Lord's 2 weeks' time may be granted, my Lord.
For what purpose?
For I will file an affidavit for having taken steps to annul the caste certificate of persons who have taken 2 certificates.
My
With regard to the Talwara, my Lord,
All right.
the others is the voluminous records which they have been produced.
17th, 23rd January.
Obliged.
Obliged.
I'll meanwhile take
let him
steps
also
to implead the applicant, my lord. I will do that.
They need to
today.
implead us, and I'll also request the copies, any additional things that they have filed it before the court for us also.
I will do that, my lord.
Please, great.
Grateful.
Number 56.
My lord,
Nagendra.
so I pray for weeks' time, my lord. I just received the instructions, 2 weeks' time, my lord.
February.
Obliged, my lord.
57 urgent, 58 is urgent. Number 59. So non-compliance of office objections for first time, 59.
So all matters which is for first time.
My lord, in this case, there is some urgency, my lord. It's a case where a sale has taken place after the period of non-alienation, but after the act came into effect. And the permission is mandatory under 4. There are 3 division-based judgments. I moved it in the vacation court, my lord. The vacation court felt that
You are for appel.
appellants.
What is the office of this?
My lord, we will clear it, my lord, within weeks. Within a week, my lord, we'll clear it. Office objection.
In all matters where it is for the first time, that is 59 to 64. 4 weeks time is granted to remove the office objections. Once the office objections are removed, the official list the matter within 3 days. So you remove within 1 week and it will be listed. And second time,
For second time, serial number
so-
65.
second time also same order.
Your lordships, serial number 63 and 64, your lordships.
64 is, we are granting time for 4 weeks.
Please, your lordship, 63 and 64. It's virtually again the second round, your lordship, despite your lordships passing an order, asking the mines department to pass a very detailed order.
It is listed for office objects. When you
Yes.
remove and it will be listed within 3 days.
Your lordship, tomorrow itself will be complied. Might I request it any day in
You comply with tomorrow and you will listed within next 3 days. That
obliged?
is what the order is.
Obliged.
Next matter.
Specific. Once the office officer have complied with, the registry shall immediately list the matter within 3 days.
Please, my lord, next matter, serial number 65, the challenge by in the writ appeal is, my lords, before the learned single judgment writ petition was filed, challenging the tender condition to the effect transportation of food grains, my lords. The condition was, in the event of there being multiple L1s, my lords, the same shall be considered by considering the number of new vehicles, because it's a transportation, my lords. This condition was under challenge. When interim order, the learned single judge said, let that condition be set aside and let the L1 be decided by lots, by lottery. That was under challenge before this honorable court, my lords. This honorable court granted an interim order on 24th December. And after the interim order was granted, my lords, the state moved the matter before this honorable court, and a submission was made, my lords, on 31st December 2024. The submission is, my lords, we will not consider that condition. We are ready to liquidate that condition.
For office objection. So remove it within 3 weeks.
And my lords, office of the copies are already been, my lords, served. Now my respective submission is, because of this submission on 31st December, it's as if they want to proceed ahead with the, despite the stay order, my lord, they want to proceed ahead based of the.
They are not hearing the matter. This for you remove and it will be listed.
And my lords, as far as the copies are concerned, they have been served, my lords. The serving the copies.
That is the only objection.
Please, my lords.
Is complied with.
All others have been.
Honored counsel for the petitioners. Appellant states that all office objections complied with.
In the meanwhile, please, if they proceed to issue the tenders, disregarding the stay order, my lords, 24th is the stay order granted by this honorable court.
Registry shall verify the said aspect. Full stop. If the office objections are complied with, the appeal will be listed immediately.
Please, my lord, there is an interim order on 24th, my lords. They make a statement on 31st, my lords, that we will not consider this, my lords. So,
within 4 days.
please, my lords, because now I am informed they are issuing the tenders disregarding the stay order by this honorable court, my lords. There is a stay order on 24th. They submit on 31st that we will proceed without considering the tender condition. This honorable court, that has to be considered on 24th. There is stay order has not been vacated by this honorable court, my lords. So, because if they issue the finalize it, my lords, specific order not to finalize.
My lord, I appear, I am the petitioner, which I got the interim order. The same was challenged by this appellant herein, who is not a party to the proceedings. In fact, it's a consent order by the government that they will not consider it.
My lords, I was a party before the single judge. My application was kept pending. The state had to, my lords, submit. The state has to submit whether they
prerogative. They
obey the order or not. It is the state has to submit on this, my lords, not a private party, because, my lords,
No,
it's not cannot be consent between the two parties and say we are not. State cannot say I am not to disregard the condition, my lords.
No, they can do that. That's what the state, my lords. They can do that. You can change it.
What is the contention of the state, my lord, whether they are going to honor the order of the court or not, they will say we are in consent with somebody.
No, my lord, what is the order is that don't look into the age of the lorries. The condition is nowhere heard, my lord. What they say is if the same parties have, there are multiple inverts, what you have to consider is the age of the lorries. This is
The
unheard of it.
This Honorable Court Larsen and Tabro, my lord, is it guidelines again, my lords. Condition cannot be interfered. It's what this Honorable Coordinate been said on 24th.
If they
Condition cannot be
agree,
interfered
if they
with.
agree, they cannot interfere. That's what I am submitting, my lord. The government, the tendering inviting authority had agreed for it. As such,
Pensioning is over. You have granted 3 weeks time. Remove
much
and
obliged.
publish it.
My lord, serial number 67, my lord.
Please.
Yes,
My lord, serial number 67, my lord.
one after another.
Yes.
Lordship, serial number 69. The main objection here is why is accused number 3 arrayed in the as a party in this proceedings?
So office of this is dispensed with for time being. These matters will be listed within 1 week.
Much of
My lord, I appear, my lords, in item number 66.
42.
It may be disposed of with liberty to challenge the endorsement had been issued in contempt.
What you have done in 42?
Your lordships, I appear for the accused number 3. It was posted for tomorrow, your lordships, for disposal.
Tomorrow it will dis-
Yeah, it was posted for tomorrow for disposal.
It is endorsement is already issued.
Endorsement have been issued. With liberty to challenge that endorsement, it may be disposed.
Learned advocate Mr. So the complainant fairly submits that the endorsement is issued by the authority, therefore the order is complied with. However, he requests the court to grant liberty to the complainant to challenge the endorsement on merits. Full stop, paragraph. Such liberty is reserved, however, without expressing any opinion on merits thereof. Also, the contempt petition is accordingly disposed.
With your lordship's kind permission, if I may mention, my lords, item number 66.
Serial number
70.
17.
70, 70.
70, yes.
That is the office objection is to file the typed copy of the receipt that has been before issuing the possession certificate. That is challenge receipt, amount paid receipt. That may posted for admission.
Which
Because-
one?
See,
Now we complete the.
No, see, I am not relying on this because after
Once
paying the amount, only they have issued the Hakupatra.
First time we have granted time, second time we have granted time, and 67 onwards, it is for 5th, 8th time. So 2 weeks time is granted. All common order, 67, 68, 69, 60, 67 and 68, 67, 1, 2, 3,
In
4.
serial number 67, my lord, there is a conditional order.
Fixed time is granted to remove the office of objections, failing which the petitions, public appeal shall stand dismissed automatically without reference to or order of the court.
My lord, in serial number 67, my lord, there is an interim order directed the appellant to deposit amount, my lord. They have not deposited, my lord, therefore, my lord, date may be.
Granted time, otherwise it will be automatically dismissed.
My lord, with your lordship's kind permission, my lords, could I mention item number
One after
66?
another, yes, Mr.
Serial number 70.
70, yes.
This is only tax paid, amount paid receipt, I am not relying on this because
Pardon?
this only they have issued the Hakupatra.
So
This is not relayed by me because the possession certificate has been given, but they have not handed over the possession of the property. The office objection is to file the typed copy of annexure B. It is not relayed at all because we have paid the amount in 2001 itself.
So
Office
type copy, objection regarding type copy is dispensed with. If need be, the counsel for the petition shall supply the same. The official list the contempt petition within 10 days.
My lord, sir.
Date may be given-
Serial number 62, man.
Date may be given for posting for hearing.
Pardon?
Date may be fixed for hearing.
Within 10 days.
My lord, serial number 71, my lord.
71.
We have preferred writ appeal on a single dates order. The official objection is raised on photocopies which are filed by the petitioner, my lord. Here in this appeal, he is a respondent. So it can kindly.
You file photocopy.
No, they have filed, my lord. We have not filed.
So then it is your appeal.
My lord, they have filed this about a photograph with a color photograph. Now they can be disposed.
So office objection regarding color photograph is dispensed with. However, the Xerox copy of the photographs which are on record shall be invariably filed. Yes.
Serial number 62, my lord. Office objection will be complying it tomorrow. 62.
All orders are passed. You remove the officer.
My
My lord, could I mention, my lord's item number 66?
Learned senior counsel is online.
Yes.
My lord, with your lordship's kind permission, my lords, if I could just mention item 66. My lord, there are three office objections that have been raised by the office, my lords. The first one is that the address of the appellant is not the same as the address of the party in the writ petition. My lord, the correct address has been provided in the writ appeal. In the writ petition, my lords, the petitioner had provided a wrong address. The second objection, my lord, is that there is no specific list of authorities. My lords, we're not relying on any specific judgment. And therefore, my lords, these office objections may be kindly dispensed with for the time being. There is some urgency in this matter, my lords, because we are supposed to comply with the order of the learned single judge by today. And therefore, my lords, because of that urgency, we move this matter, in fact, before the vacation bench
66.
also.
Yes, 66.
66, my lord.
Office objections in the nature of inaccurate address of the parties and filing of the judgments.
Yes.
Are dispensed with.
There is one more, your lordship.
Hello.
In the office objection related to the other respondents' reply not being part of it.
That is to be filed.
Lordship, we ourselves were
My
responding.
lord, serial number 56, my
It
lord.
was served upon us.
Whatever record is there, you have to
My
file.
my lord,
We
serial
will
number
file it, my
56.
lords. May I request that this matter be listed for admission sometime at your lordship's convenience this week?
We shall verify the.
My lord, the serial number 56, my lord.
Yes,
I'm pressing for.
And if they are complied with, the appeal shall be listed within 10 days.
Deeply obliged, my lord. Deeply obliged.